May I have your lordship's leave, my lord, to file an appeal without the certified copy? The order was passed in May 2025. My lord, I'll indicate the situation. It's a changed brief.
Whatever the situation be, it's not your personal brief, sir. It's your client's brief. If
But
your client
my
thought it fit to wait till date, when did you apply for certified copy?
Lord, it was applied on September, my lord, 2025. My lord, I
No,
have
no.
the letter, my lord.
Wait for
It's
it.
an original summons suit, my lord. I was not a party to the proceedings, my lord. I filed an application. It was rejected, my
If
lord.
you don't get it within a reasonable time, come and mention, we'll permit you.
Very well.
May I,
May I permitted to mention matter for inclusion in the list, lordship?
Yes, yes.
may I have my lord, the sky leave to mention a matter for inclusion, my lord?
Inclusion, hand up the slip, please.
My lord, one indulgence. My lord, it's a 37 appeal. The pleadings have been complete, but however, it's a changed brief and have been not been able to obtain an NOC from the erstwhile advocate. So I'm seeking leave to file my Vakalatnama without the NOC also, my lord.
No, we can't grant you leave. Do whatever you can. We can't grant you leave.
My lord, the matter may be included in the list. My lord.
Why, at your instance, you still don't have a wakalat? How can we? No.
Lordship,
Yes.
may I mention this matter? Lordship, item number 33 is appearing in today's list, your Lordship. If the matter can be fixed any day, your Lordship, as per your convenience, if the matter can be taken up before the pujas, your Lordship.
Sorry, we can't
Lordship,
give
the petitioner is an
any,
old lady. Your
we
Lordship.
can't give any preference to any matter before the vacation. Try your luck after the vacation. Immediately after, we'll try. Yes.
Separate side mentioning.
আজকে তো let's say non-commercial.
My lord, for inclusion, contempt application. Grateful, my lord.
Let's say non-commercial item number 1.
Oh.
Family.
আমাদের এসছে কিন্তু ওই পর্যন্তই বুকটা পর্যন্তই, তারপর তো আর মনে নেই।
Mr. Dev, we will go through the papers during the vacation. We'll keep this matter again just for further hearing if we need any clarification.
Lordship.
That is why we have
Lordship.
a Lekho Eta. Let this matter be listed immediately after the puja vacation. Reopening day?
Any day, any day, any day.
Date ta diye dao bracket e. Under the heading for further hearing.
Order আছে
Lordship.
so grateful, my lord.
Item 2.
Please, my lord. We'll go through the papers.
My lord.
So we'll keep it at
Deep reverence.
Item 3. Lord, I am for the plaintiff appellate. I shall tell you, Lordships, very briefly.
Before that, what club is this? Mohanlal Club?
It's an old
Initially,
club.
I read it as
I
Mohan Bagan.
made a mistake.
It's a Mohan Bagan Club?
No.
No.
It was possibly, my lord, at the initial stage, Mr. Pankaj Rai was there. Then, my lord, I'll tell you, Lordships, very briefly the fact.
And we have filed that application for intervention, my lord. We say that, my lord,
It
we are
has
the
to be mentioned. Let it be listed any day tomorrow.
I'll tell you, Lordship, the whole difficulty. This intervention application, for obviously for one reason. Not to, my lord, allow my clients, my lord, to be there. My lord, I will tell you, Lordships, very briefly. My lord, it's an old club. The documents annexed to the plain petition would, my lord, show that it's an old club. Now, from the very beginning, my lord, the office, it did not have initially a registered office. Now, from the very beginning, my lord, the office of the club, or the main office of the club, was situated at the residence of one of the office bearers. Maybe secretary, maybe somebody else, but one of the office bearers. This was continuing. There was no dispute, my lord, till 2020. In 2020, my lord, the secretary expired during the COVID. The club was, my lord, the address of the club was his residence. Then in 2021, my lord, the members of the governing body, they held a meeting, appointed a secretary, appointed a treasurer, and shifted the address. It was intimated to CAB. CAB accepted that. CAB accepted that. CAB accepted the, my lord, secretary and, my lord, the treasurer as the, my lord, the persons.
Why was it necessary for CAB to accept? I mean, these clubs are all.
No, now CAB has taken a turn. CAB is now saying, no, I do not know you. For after 4 years, CAB is trying to say, I do not know you because the election of the odd my lord, a meeting of CAB is scheduled to be held on 22nd.
No, these clubs are all registered with CAB or
Yes,
registered with
yes, a
CAB?
member, affiliate club.
Affiliate club. I see. So CAB is a supervisory body. I'm trying to understand what
Yes,
is the equation between CAB and this club.
my lord, this CAB is the parent body. They, my lord, do everything, my lord. These clubs play under CAB.
I see.
There's different, my lord, the first division, second division
I see.
leagues.
I see.
Those are played under CAB, like IFA, my lord,
I see.
played under CAB.
I see.
Now, the whole difficulty is, my lord, the election is on 22nd. We came to know that, my lord, CAB is not trying to, my lord, not recognize us. Though recognized us, there are the documents to show that from 2021 till, my lord, early 2025, CAB was recognizing this governing body. Now, my lord, they are trying to avoid that. That is why they suit.
And may I make some?
Lordship,
The
I am appearing
election,
for
the
CAB.
meeting is on 22nd, my lord. That is the main urgency.
Have you served all?
Lordship, I am appearing for CAB.
CAB.
I have only one defendant, my lord. I have claimed relief against CAB only. That CAB cannot do this. After recognizing me for 4 years, you cannot do it.
Tomorrow before original site.
I am obliged.
A application.
No.
Already the matter was before the ombudsman, my lord.
Very
Ombudsman
well.
passed an order, my lord. That order is not under challenge.
CAB is there
Hear
to
them
protect
first,
his
Mr. Sen. We don't know who you are.
My lord,
You are not a party.
I'm the, my lord,
File your
affiliated
independent
club.
proceeding. Who stops you? If you have something to say, file your independent proceeding. Mr. Sinha is appearing.
Proceeding.
It now. Kalke application before original site.
I am obliged.
Kalke ki jo fix this here. Kalke. What's happening? ও হ্যাঁ মনে আছে এক সাইড মনে পড়ে গেছে এটা এই নিয়ে লাভ নেই আমার আজকে কোনো
My lord, in this matter, my locus standi has been questioned by this learned state advocate, and they have sought to file affidavit in opposition in the contempt application, my lord. My lord, more than 1 month has been gone by, no affidavit has been sought, and I am sure my learned friend will seek time. They are in contempt since 2019, and they are still seeking time.
But this is registration of
Eco-friendly battery operated electric vehicles, in which I am having the patent. My lord, I am directly
opposition already ready, my lord. 2 weeks time may be given after vacation.
by 5th of August we had granted
I
time.
have already ready, my lord.
Then why we need 2 weeks time? If it is ready,
one week time, I have affirmed the person.
file it on Monday. For affirmation, you don't need more than 1 day. If it is ready,
Drafting is ready, my lord. Settling not settled that matter.
file it by the last day so that we can take it up immediately after the vacation.
Yes,
File it by next Friday.
next Friday. Right.
On the request made by learned advocate for the alleged contempt laws, time to file affidavit in opposition is extended till September 26, 2025, stop. reply thereto, comma, if any,
Within 1
not
week,
within 1 week.
my lord.
Be filed within 1 week after vacation.
My lord, within vacation, I will prepare it. I will file it on the reopening day.
Be
I will not
be
drag it.
filed by November 3, huh? By November 20, November 31, October 31, October 31. 1 week. Paragraph lists the matter on the following working day, under the appropriate heading.
I shall file. My lord, I think, my lord, that only, my lord, I have to, my lord, they take exception to the, with regard to, my lord, the maintainability.
We have recorded that in our first order. All this is without prejudice to your question of point of maintainability.
Wait.
26.
Lord, I am for the applicant. Lord, the last occasion the matter was taken up for hearing, but only any was not service, it was affected. Again, I served the notice. Service
This is about 37.
No, this is the item 5. This is a service already affected. This is a prayer for leave to appeal.
The কাগজ একসঙ্গে ভরিয়ে দেয়।
Lord, the Lord, may I like to, my lord, submit a short list, my lord, so that I come before this court.
Who is the answering respondent? NHAI.
NH.
But have you served the state?
Yes.
State service to go.
The state service earlier occasion they filed already appeal service is there. The last week, my lord, the only NH was the service was not
আরে
affected.
ভাই তো এসব এমন ভাবে রয়েছে কাগজ আমি মেমোটা খুলতেই পাচ্ছি না।
But today, my lord, the leave to appeal. Leave to appeal টা আগে যাবে।
আরজু অ্যাপিয়ার করেন না NHAI এর
ক্যান নাম্বার 3 টা আগে যাবে।
করেছে আমাকে কিছু মধ্যে NHAI হয়ে গেছে।
মেমোই পাচ্ছি।
লিভ টু অ্যাপিল আছে
এতে কিছু একটা গড়বড় আছে মনে হয়।
ক্যান নাম্বার 3
NHAI পেয়েছে আজকে একটা ফাইল করেছে।
ক্যান নাম্বার 3 বড় ফাইলে ক্যান নাম্বার 3 টা দেখুন লিভ টু অ্যাপিল আছে। হ্যাঁ, লিভ টু অ্যাপিল আছে।
আজকে পাঠানো।
হ্যাঁ, ক্যান নাম্বার 3 টা আগে হিয়ারিং হবে তো, লিভ টু অ্যাপিলটা ওটা না, আরেকটা মোটা আছে। ক্যান 3 লিভ টু অ্যাপিল। হ্যাঁ, লিভ টু অ্যাপিল।
ভলিউমের পরের পেজ একটু মোটা হতো, ওটা ক্যান সেকশন 5 দিচ্ছে।
এটা আপনি সেকশন 5 টা দিয়েছেন।
দেখুন না সেকশন
কন্ডোনেশন দিলেন, লিভ টু অ্যাপিল একটা আছে। না না,
এইটাও
The award has been set aside by the impugned judgment.
yes.
Award has been set aside.
Lord, the things for a moment are just lordship drawing attention, my lord, short list, my lord. Why come before lordship?
No, no,
Everything, that's okay. Just okay. Short term FX.
Mr. Maiti, please do us a favor. This is a matter where your other side should be present. Mr. Arjog Dotto often appears for NHAI. Please approach him once. If he says he will appear, give him the papers, let him come. We'll keep it on Tuesday. We want to hear him or anybody else on behalf of NHAI. If Mr. Dotto cannot appear, we will take it up ex parte because they have received service. We have seen that.
Try my level. Try my level.
Just try Mr. Dotto. Affidavit of service filed in court today be kept with the records. Paragraph. We see that NHAI, Purota Diye Debe, National Highways, has been served. Stop. Nobody appears for NHAI. Purota Diye bracket in short NHAI. Nobody appears for NHAI. Paragraph. Paragraph. Mr. Arjog Dotto, learned advocate, often represents NHAI in court proceedings. Stop. We request Mr. Maiti, learned advocate for the intending appellants to ascertain from Mr. Dotto if he would be able to represent NHAI in the present proceedings. Stop. If he agrees, Mr. Maiti should make over the appeal papers to him. Paragraph. List this matter once again on Tuesday, date the other, retaining its position. Yes. Learned advocate on record for the intending appellants is requested to forward a copy of this order to NHAI. You are for?
Respondent number 2.
The state.
The state.
NHAI is the answering respondent. So we have requested Mr. Maiti to ascertain from Mr. Arjog Dotto, who often represents NHAI, to the best of my recollection. And we have kept this on.
I speak to him.
Yeah, we have kept this on Tuesday.
Appeal from section 34 in any case, there is no scope for any interim order.
First, whether we should grant leave to appeal. There's an application for leave to appeal. Apparently, the award, if I remember correctly, in the award, they were not beneficiaries. The award said something like this will govern all cases. There's some problem with the award.
But the section 34 is on the limited ground that the compensation has to be in terms of the 2013 Act and not the Land Acquisition Act.
We have not seen any papers. We'll consider.
We can take.
Take to appear for the appellant lot.
It will govern all the
Yes.
This is an appeal from the section 9 of the Arbitration Conciliation Act, where
You are for the respondent. Allow us to go through the order. The impugned order is dated 21st July.
21st.
Yes.
21st of July. What a question. Should I? What a question. That was a patient.
It is the initial order থেকে What is the status of arbitration?
It is pending. Item number 22, they have filed their written affidavit in opposition. It's at the stage of final.
When was the first ad interim order passed in your favor by the learned trial court?
Trial court.
Possibly ex parte?
4th of October 2024.
24.
24.
And when did you issue section 21 notice?
That is a
It is section 11 law.
section 11. 11 6. But this is their opposition. 20.
Education.
Yes.
11.
30th of January. 30th of January 2025.
Beyond 90 days.
30th of
October, November, December.
October.
4th of October or 30th of January?
30th of January.
Beyond 90 days from the date of the first order.
October, November, December. Oh, yeah.
4th of October, the order was passed.
November, December, January. Beyond 90.
November, December.
Why don't you go for mediation?
Lordship,
There seems to be some.
The dispute is not covered by arbitration.
You are, that we'll see. Do you want to go for mediation? Your client claims to be the owner of the land,
Lordship.
the principal of the institute, as also a trustee. They are also.
A fight between the parents, daughter, brother.
They are also trustees. This is a fit case for mediation.
Your Lordship, if your Lordship
Settle it.
Yes.
Lordship, the advocate on record for the lower court is present. He said that he has already attended mediation.
But said it was failed.
Mediation has failed.
Mediation.
Proper mediation by a trained mediator. It was referred by the trial court.
Not by the trial court, it was referred by the High Court, Honorable High Court.
Which
Justice Joy Senutor matter ওই সময় ওখানে দিয়েছিল কি
Lordship, I'll inquire.
অন্য dispute না এই dispute
trustee related dispute তখন ওইখানে
that was in relation to say there were some differences between the trustees, therefore some criminal matters were filed. No, criminal, civil
matter.
Anyway, not
Lordship,
in regard this arbitration
not
proceedings
regard
or
to
mediation.
this? Why don't you try out?
Lordship, I'll
Huh?
obtain instruction.
জেনে 5 মিনিট পর একটা ইনস্ট্রাকশন
Mediation এর আবার instruction মিটিয়ে নিতে বলে মিটিয়ে নেবে স্যার বকবে না
ছেলে দিন জানুয়ারি
Oh, you want to take instruction? Which cable?
হ্যাঁ হ্যাঁ
You want to take instruction? Take instruction. Come
Don't
back.
have any objection.
Very well. Isho, we'll record a short order. This appeal is directed against an order dated July 21, 2025, passed by the learned additional district judge, North 24 Parganas at Barashat in miss case number 47 of 2024, bracketed arbitration, bracket closed, being an application under section 9 of the Arbitration and Conciliation Act, 1996, filed by the respondents herein. Stop. Paragraph. The brief facts of the case appear to be that the appellant is the owner of a plot of land. Where is this?
It's Begonga, near 30 Thakurhat Road.
Thakurhat Road.
Thakurhat Road is that road which goes from Bodgamgram towards
No, but Barashat. This is in Barashat. Plot of land in Barashat. Top. He appears to have executed a lease in respect of the land. Huh? नहीं.
Where's the arbitration clause?
yes,
Arbitration clause is page 38 of my CAN application. Clause 6.
No.
Running page 38 of my stay application. Lordship, point 6. Clause 6. Is our contention that the dispute that is covered is when we exercise the so-called right of preemption.
এখানে valuation is also a dispute. এক পক্ষ বলছে petitioner before the trial court বলছে যে appellant in spite of request value করছে না। এটা কি আমরা দেখবো? নাকি সেই arbitration clause তো রয়ে গেল। Width of the arbitration clause এটা কি আমরা দেখবো? এই এগ্রিমেন্টের বাইরে হলে তো আর হবে না। এই এগ্রিমেন্টে তো আসবে না। Direction কি otherwise arbitrary power আছে?
Subsequent judgment
আপাতত তুই ওদের পাঠিয়ে দে।
Lordship, the lease has already expired.
Yes, we have seen that. Have you filed a suit for their eviction?
Yes.
You have also filed a suit. The eviction cannot be.
For the eviction.
Thank you. You will executive lease in favor of a trust which constructed a building on the concerned land for running an educational institute by the name of Institute of Genetic Engineering. Stop.
Biotech Foundation is trust.
Paragraph. The appellant and the respondents are all trustees of the said trust. Stop. The appellant is also the principal of the said institute. Stop. The lease has expired by efflux of time. Stop. The appellants and the respondents are related.
Yes, related.
It appears that disputes have arisen between the appellant and the respondents who are related to each other.
Appellant is the ex-principal.
Oh, the appellant is ex-principal. Ex-principal bolechi?
Related father, daughter.
Closely related করে দাও. Stop. Paragraph. We see an element of settlement in this matter. Stop. We propose to the learned advocates. We inquired of the learned advocates as to whether or not their clients are agreeable to go for mediation. Stop. Learned advocate for the respondents herein says that his clients have no objection. Stop. Learned advocate for the appellant seeks a little time to obtain instruction. Tuesday, paragraph lists the matter.
Grateful to your lordship.
Item 7.
Item 7, my lord, is my appeal arising out of a Section 9 order. My lord, before my lord reads the impugned order, may I just take 1 minute of my lord's time to give a background? It's a simple case, my lord. There was some miscommunication on the part of my client, for which reason the learned trial court, my lord, has passed a really harsh. 50,000 costs is not, that is a portion of my grievance, but the real grievance is the hypothecated vehicle has been directed to be handed over to the borrowers who are admittedly in default. May I just give a short background just for 30 seconds, because the impugned order or else won't make sense, because this is an impugned order recalling in effect a prior order and passing a further order, a mandatory injunction directing the receiver to hand over. Here, my lord, the respondents before my lord are the borrowers. They had taken a loan from my client, my lord, for purchasing a truck, a Tata LPT truck. 43 lakhs about was the total loan amount. It was payable on 65 monthly installments, about 96,000 each. In 2024, they had defaulted. There was still an outstanding of about 9 lakhs, for which reason we approached the City Civil Court in a 2024 Section 9 petition for receiver to be appointed over the hypothecated asset. And the truck is hypothecated with us. We have a charge on the truck. 2024, a Section 9 order is passed whereby a receiver is appointed, first and foremost. That order is carried up in appeal by the borrowers before this honorable court. This honorable court, my lord, directs ad hoc payments to be made. A coordinate bench of this honorable court, my lord, directs ad hoc payments to be made, of which, my lord, one of the conditions was that the receiver already appointed would remain in symbolic possession. So the honorable court did not discharge the receiver and did not set aside the finding of the trial court whereby a receiver was required over the hypothecated asset. Ad hoc payments were directed to be made. Initially, 2 lakhs was paid by my learned friends for the borrowers. Thereafter, another 1 lakh was directed to be paid, and the appeal was disposed of on the condition that they will pay 1 lakh and continue to make EMI payments. That was the condition on which the appeal was disposed of. And in default, the appeal court also categorically recognizes my right to seek repossession if they default in making future EMI payments, because substantial EMIs were still outstanding. Not only did they delay in making payment of that 1 lakh, the appeal court in subsequent, there were CAN applications filed in the disposed of appeal for extension of time to make payment of 1 lakh. There, the appeal court categorically finds that their conduct is poor, that they have not come forward with a case where they show ready and willingness to pay. Thereafter, eventually 1 lakh is paid, but thereafter not a single penny. From February 2025 till August 2025, not a single penny paid, though there was EMI installment payments due, and there was already 9 lakhs due on people. Now, my client, admittedly, this is where my client is at fault. My client was not informed by the Delhi office. There are 2 branches. The loan was executed in West Bengal in the Kolkata office. The Delhi office had taken steps to
The Delhi office is not your client.
it is my client. That's a fault on my clients, but Manoj, I do not shy away from that. I must admit, absolutely, Manoj, there was some inadvertence. I must be candid, Manoj. I cannot shy away from that. That's why 50,000. I cannot say much as to the costs. Now,
What, they had obtained an award?
They had obtained an award. Now this
Expertise,
award,
no.
yes, expertise.
Expertise.
That award is that I am not on the award either. Today, Malad, Section 9 proceeding, I am not on the award. What fault has happened is we have thereafter issued a loan recall notice and a fresh Section 9 was filed in 2025 seeking possession of the vehicle and appointment of receiver without disclosing the award. That is an absolute fault on our part, Malad. I cannot shy away from this. Because separate branches
যদি অ্যাওয়ার্ডটা মেনশন করতো কি হতো? Award থাকলে তো it becomes a stronger case.
Section 9
Yes.
substitute of section 36.
Correct. So how has the court erred, Mr. Mukhopadhyay?
Yes, my lord, my only submission today is, admittedly, there has been suppression in the petition. I cannot shy away from that. There has been.
Yes.
My only grievance is that while vacating the order and also directing the receiver who had taken physical possession of the vehicle, my lord, the court should have at least considered costs are one part of it. I cannot say anything because admittedly my client is at fault. But a balance of convenience has to be looked at to a degree, even at that stage. Because this is a Section 9 court. The court did not, and I have categorically stated that. I filed a written objection where I have categorically stated not a single penny was paid after February of 2025. Not a single penny.
Go and execute your award. Who stops you?
Malad, that execution, that also, Malad, we will take steps. I've taken that instruction. Only one thing today, this Section 9 order is staring at our face, whereby a receiver has been directed to hand over possession of the vehicle free from any encumbrance. They are at liberty to do whatever they like with the vehicle right now. I am only seeking a limited protection. I am not saying anything further on the merits of the matter. Limited protection only, that let the receiver continue or at least in symbolic possession of the vehicle, and let them at least inform us as to where the vehicle is, or else we will lose the charge. We will lose the vehicle. Balance of convenience is the only point in this appeal, nothing more. Lord, I completely cannot lay blame on the learned trial judge for vacating my initial order. It was on suppression. I cannot say anything. But my lord will kindly appreciate a Section 9 court will also have to look at the default, whether there is one to a degree, and a balance of convenience has to be arrived at.
The application on which the initial order was passed, which order was carried in appeal?
Yes, my lord.
On that very application, the subsequent order was passed? No.
No, subsequent. The original application was thereafter dismissed.
Application is one, Section 9.
No, there are two. 2024, there was one.
That was disposed of.
That was dismissed. Initially, the appeal court had directed that they have to make monthly installment payments. In default, we can approach the learned trial court for repossession of the vehicle. We did not file a fresh petition in that Section 9 for that repossession. We filed a separate.
So what happened to that earlier
It's
Section
been dismissed for default. That also
it has been dismissed.
Has been dismissed for default. That was still alive. That was dismissed for default. This is the miscommunication gap between this. Today, my client will take steps to file an execution proceeding.
So in the second Section 9, you obtained an ex parte order when they came and pointed out that there is already an award.
Yes.
Then this impugned order was passed.
Impugned order was passed. ঠিক আছে, ঠিক আছে। ঠিক আছে, ঠিক আছে।
What do you have to say, sir?
My lord, kindly see page 48, their application under Section 9. specifically what they have stated, they have not stated anything with regard to any arbitration. They have particularly stated in section 9 that they are going to start with the arbitration, commence with the arbitration, and on that accord, they have taken out the order under section.
Mr. Counsel, tell us one thing. Mr. Mukhopadhyay fairly admits that the
Yes,
conduct of his client
that
cannot
is
be excused, but
Milord,
our money is due.
Yes, Milord. But Milord,
Then
kindly,
what we propose to do, listen to us first. Listen to us. Don't be so impatient. What we propose to do, either we are not taking back the vehicle immediately. You have given it to him.
no. We have not been
yet the
handed
receiver.
over.
It was with the receiver. The receiver is
Receiver is not
that's
picking
the
up the
direction
call.
that is under challenge. That
The receiver, either the receiver, symbolic possession, you can have physical possession, or we'll injunct you from dealing with that vehicle for a particular
Milord,
period
we'll
of
give an undertaking that will not sell it or alienate it.
No, we will pass an order.
Oh.
We'll pass an order.
and Milord,
The execution.
And Milord, we have already challenged arbitral award because it was an ex parte award and it was an unilateral appointed arbitrator was appointed.
You have already challenged it.
Yes,
but there is no
before the
stay.
Roanoke court.
Firstly, Milord, it's before a court, Milord, which has no. I'm not.
No,
on that.
Milord,
No,
the arbitral award has been passed in Delhi.
The arbitral award
Section
was passed
34
in-
has been filed in Rohini.
Seat is in Kolkata, but Milord,
But
no stay of operation.
seat is
No
not in
stay of
Kolkata.
operation.
We are not concerned.
My lord.
We'll just record that fact. They have filed. Who was the arbitrator? Your man.
Yes,
Not
Milord.
no,
Yes,
no, it
Milord.
was a
Milord, ma'am.
council. It was an institution which was referred to in the agreement. That's there, Milord. The award
Doesn't fall foul of 12.5.
Milord, in view of unilateral appointment.
Anyway,
I
we are
won't
not.
say anything on that. I won't say
We are
anything
not
on
on
that.
that.
Milord will not.
Issue. This appeal is directed against an order dated
Order dated 11th September 2020.
September 11, 2025, passed by the learned bench dash Roman 11, City Civil Court, Calcutta, in Miss Case number 12129 of 2025, being an application under Section 9 of the Arbitration and Conciliation Act, 1996, filed by the appellant herein. Paragraph. It appears that the respondents, how many respondents? Two.
Two borrowers, both of them.
The respondents availed of loan facility from the appellant finance company in the sum of approximately rupees 43 lakh for purchase of a truck.
Of a truck.
Truck. Stop. The truck was hypothecated to the appellant as security for the loan amount. Stop. The loan amount was repayable in monthly installments. Stop. Paragraph. According to the appellant, the respondents defaulted in payment of monthly installments and a sum of about rupees 9 lakh
Today 10 lakhs it will be. Today
became due and payable. Stop. The appellant approached the learned trial court with an application under Section 9 of the 1996 Act, praying for appointment of receiver over the hypothecated truck. Stop. The learned trial court passed an order appointing receiver, directing him to take physical possession of the vehicle in question. Stop. Paragraph. That order was carried in appeal by the respondents. Stop. A coordinate bench of this court modified the order by directing the present respondents to pay some amount upfront and to continue paying the installments. Stop. The receiver was directed to be only in symbolic possession. of the vehicle. Stop. Paragraph. It appears that thereafter, sometime thereafter, the present Section 9 application was filed by the appellant herein, comma, the earlier Section 9 application having been dismissed for default in the meantime. Stop. In the present Section 9 application, the appellant obtained an ex parte ad interim order for appointment of receiver over the vehicle in question. Stop. Such an order was passed on
30th August 2025.
August 30,
Yes.
2025. Stop.
That order, my lord, will find at page 75.
That's all right.
Right.
2025. Stop. Paragraph. On the returnable date when the present respondents appeared before the learned trial court, comma, they brought it to the notice of the learned trial court that the appellant has in the meantime obtained an ex parte arbitral award against the respondents. Stop. The learned trial court took a serious view of the suppression of this material fact by the appellant oblique petitioner, and he has dismissed the application.
No,
it is
vacated the order.
because there's already a direction for the receiver to have. For compliance, it's been kept. For compliance by the receiver.
কি বললাম? And vacated the order and directed the receiver to hand over possession of the vehicle to the respondents. Stop. The trial court further directed the appellant oblique petitioner to pay cost of rupees 50,000 to the District Legal Services Authority, Calcutta. Calcutta. Stop. Being aggrieved, the appellant has come up before us. Paragraph. Mr. Mukhopadhyay, learned counsel appearing for the appellant, in his usual fairness, says that he cannot justify the conduct of his client. Stop. It appears that the Delhi office of his client had proceeded to obtain an ex parte award, ex parte arbitral award against the respondents. Stop. Because of communication gap, that fact was not mentioned in the Section 9 petition. Stop. He very fairly says that he cannot find any fault with the order under appeal, as such, but the balance of convenience requires some protection for the security that for the vehicle, which is the appellant company's security for the loan advanced to the respondents. Stop. Paragraph. We have not called upon, now we have also heard learned advocate for the respondents. Stop. He makes a serious grievance which is justified, that there was gross suppression of the fact that the appellant oblique petitioner has already obtained an arbitral award against the respondents. Stop. He says that he says that his clients have challenged the award, ex parte award, before
the district court, Rohini, Delhi.
Before the district court,
Rohini, Delhi.
Rohini, Delhi, which is the appropriate forum. Stop. Learned advocate for the appellant disputes that the district court at Rohini, Delhi is the competent forum. Stop. Paragraph. Having considered the rival submissions made on behalf of the parties, we appreciate Mr. Mukhopadhyay's fair stand that his client's conduct cannot be condoned. Stop. The trial court was absolutely justified in undoing the earlier order that it had passed in favor of the appellant on the ground of suppression of very material facts. Stop. Had it been disclosed in the Section 9 petition that the appellant oblique petitioner has already an arbitral award in its favor, we doubt very much that the trial court would have passed any order on the Section 9 application. Stop. This is because the obvious relief of the appellant would be by way of execution proceedings. Paragraph. We only modify the order of the learned trial court. We do not see any reason to set aside the order of the learned trial court. Stop. We only modify however, considering the question of issue of balance of convenience and inconvenience, and keeping in mind that the vehicle in question is the security for the appellant company for the loan advanced by it to the respondents, a portion of which has admittedly fallen due, we modify the order of the learned trial court to the extent that the receiver shall continue to be in symbolic possession of the vehicle only. Stop. We do not interfere with the portion of the learned trial court's order which directs return of physical possession of the vehicle to the respondents. Stop. And pay the cost for a good cause, pay it. You are a big company, Mr. Mukhopadhyay.
Very big company.
Only one prayer, my lord, as to at least the quantum, if some relief, some reduction in the quantum, at least some cost has to be paid, my lord. I kindly, my lord, will kindly consider.
We can increase it, Mr. Mukhopadhyay, because of your client's conduct.
My lord,
we can
try
increase
to
it.
explain it. If my lord kindly consider some my lord, reduction, my lord, will kindly consider.
They should be more careful in the future.
Of
They should learn a lesson from this. Paragraph. We do not interfere with the other portions of the order under appeal. Paragraph, the appeal and the connected application are accordingly disposed of.
My lord, one more prayer, my lord, will kindly injunct them from selling, transferring.
Receiver continues in symbolic possession.
My lord, at least so that.
Don't you think that will be contempt?
My lord, absolutely. My lord,
Equal contempt. If they breach an order of injunction and if they sell when receiver is in possession.
My lord, only one humble prayer, my lord, since these are trucks, they travel long distance. If they can inform the receiver as to the whereabouts of the trucks, as and when required, only that much. The receiver.
একটা খালি বলে তো হ্যাঁ Huh. The respondents shall inform the receiver as regards the whereabouts of the truck in question as and when called upon by the receiver.
And as to the amounts that have fallen due, they should at least continue to make whatever payments. They admit today, they are here today admitting that there is amount.
It's nothing more, mister. Nothing more.
That is under 34.
Nothing more.
No stay on the award.
You execute if you can.
Only considers that this is a defaulter who's.
We have protected your security, Mr. Mukhopadhyay, in spite of your client's abhorrent conduct. Very bad conduct.
Deeply obliged.
Justice Shujoy Paul was very impressed with the debate wherein you participated.
Grateful, my lords.
Was the motion carried through?
We defeated the proposition, Lordship.
You
The proposition was digital times, the due process of law is not adequate to meet the challenges of digital times.
Achha.
We were the opposition and we won.
So you established that due process of law
Is
adequate
and it cannot be defeated, even though there are challenges of the digital times.
Yes, Mr. Banerjee.
Although we are largely benefiting from digital times, but
Yes.
Milord, before I resume, Milord, I should confess one thing. Milord, in the meantime, I have come across two decisions, recent decisions, which are against me. Milord, I will place those decisions also. But Milord, after having held against me, Milord, the other bench of the Honorable Supreme Court has again, Milord, referred the matter to larger bench. So, Milord, there was a reference by Milord, the Honorable Bench, Milord, presided over by Milord Justice Khanna. Now, Milord, there is, Milord, another, Milord, reference, Milord, by another bench, Milord, presided over by Milord Justice Narasimha. Milord, that, Milord, I, Milord, failed to take notice of earlier. So, Milord, I will place that also, which is not, Milord, included in my, Milord, notes of argument. Milord, held against me. But because of, Milord, there is a, Milord, divergence of views, Milord, of Justice Narasimha's views and, Milord, the previous decisions. The matter has been referred to, Milord, a 5 judges bench. And, Milord, so far as my knowledge goes, Milord, the larger bench has not taken up the matter.
So which decision holds forth now?
Yes.
Previous should.
Previous. Which are in
if
my
it's
favor.
equal strength.
Which are in my favor. So, Milord, my first argument was that unless my learned friend's client was a supplier at the time of entering into the contract, Milord, he was not entitled, Milord, to approach facilitation counsel. And, Milord, I have indicated that, Milord, there are two definitions, separate, Milord, different definitions under the Act. One is, Milord, definition of enterprise and the other one is, Milord, definition of supplier. Section 8 says, Milord, in order to be a supplier, one has to, Milord, file a memorandum. Milord, I stuck on the last occasion, Milord, on that may and shall, Milord, in section 8. If my lords kindly take the trouble, Milord, to once again have a look at section 8. Because section 18, my lords have kindly seen that, Milord, a dispute between a supplier and a buyer is, Milord, a dispute which can be referred to, Milord, conciliation to be followed by an arbitration before the facilitation council. So, Milord, it's not a dispute between an enterprise and, Milord, a buyer which can be, Milord, taken to facilitation council. Now, Milord, who is a supplier? If my lords kindly take section 8. Milord, I have also indicated the definition of supplier 2H. Milord, I am not troubling your lordship with that again. Kindly take, Milord, section 8.
You are BESCO.
I am, Milord, BESCO. And, Milord, the supplier, alleged supplier is my learned friend's client, Jaggi Brothers. Kindly take, Milord, the proviso. It says, Milord, before proviso, subsection 1 says, any person who intends to establish. That means, my lord, who intends to establish after, my lord, this act being enacted.
MSME Act বাবা মামলা হচ্ছে দেখো তো খেয়াল করবে না এগুলো
I'm sorry.
MSME Act we have it
Sorry, my lord, I should have
খুঁজে দাও
noticed. My lord, Justice Rai is having a copy, but I have, my lord, a copy. May I, my lord, hand up, my lord? I have, my lord, extra.
I also have a copy. Yeah.
তোরটায় অন্য কিছু লেখা থাকলে
No, no, nothing.
Section 8 of the 2006 Act. Subsection 1 deals with those enterprises which are established after promulgation of the Act. It says the opening words are any person who intends to establish. Then comes the proviso. And for those who intend to establish when the Act is coming in force, for all of them, the expression used is shall. After A, B, C, shall file memorandum. Then comes the proviso. Provided that any person who, before the commencement of this act, established a small-scale industry and obtained a registration certificate may, at his discretion, and an industry engaged in the manufacture or production of goods pertaining to any industry specified in first schedule to the 1951 Act, having investment in the plant and machinery of more than 1 crore rupees, but not exceeding 10 crore, in pursuance of notification of government dated such and such, filed an industrial entrepreneurs memorandum, shall, within 180 days from the commencement of this act, file the memorandum. My lord's read, the proviso, like the shall should have been, be a part of clause B. Shall should have been there in clause B itself. Should not have followed clause B, should have been there in clause B itself. That was my lord's reading. I go by that interpretation. So for a small scale industry, there is a discretion. For an industry engaged in manufacturing or production of goods, which is falling under first schedule to the 1951 Act, for them, it's a mandate to file a memorandum. Now, kindly just have a look at 1951 Act. I have a soft copy today. Will kindly take it from me. The first schedule deals with metal items also. May I just indicate that? May I read it out for your lordships? The first schedule, clause A, serial number 1, says iron and metal, steel. May I hand up a soft copy for the time being? I have sent for a printout. I have sent for a printout. It immediately arrive. And I'm sorry, I should have come up with this.
Schedule 1?
Schedule 1, first schedule, FIRST first schedule, serial number 1, clause capital A, then under clause capital A, item number 1. All iron and steel materials.
This is of this 1951 Act.
Yes. And there is a residuary clause under the first schedule, serial number 7, which says other products of iron and steel. So all products made of iron and steel are covered. Now, if my lords kindly take the stay application can 1, kindly have a look at page 27 once of the stay application. Page 27. Milord, this is Milord, the registration on which my learned friend is relying, Milord, previous registration before 2006 Act, Milord, came into operation. Kindly see, Milord, the nature of activity. MS scrap processing. Metal, steel, Milord, scrap processing. Which, Milord, falls under, subject to, Milord, of course, correction by your lordships, falls under, Milord, first schedule of the 1951 Act. Milord, that was indicated in the registration under, Milord, the state legislation. Then, Milord, they applied for, Milord, registration under the MSME Act. And, Milord, that application is at page 26. Kindly, Milord, turn to 26 capital A of the application. I'm sorry, Milord, kindly take page 25 first, then, Milord, kindly take 26 capital A. Kindly come to page 25, Milord, once. Milord, the activity, Milord, kind of activity they have, Milord, proposed to carry out is indicated, Milord, in the box, in the third box at page 25. Manufacturing activity. And type of enterprise, Milord, at the top on the left-hand side, Milord, this is major activity, is manufacturing. So manufacturing of, Milord, metal scrap or, Milord, metal steel or metal rail, which are all covered under first schedule, Milord, of the 1951 Act. Even at page 26, capital A, Milord, major activity is indicated towards the right-hand side at the top. It's manufacturing. Milord, this is the first schedule, Milord, of that. আমি দিয়ে দিচ্ছি, এটা যদিও আইন তাও মানে একটি দিয়ে দিচ্ছি। So, Milord, under first schedule, clause 1, capital A, both, Milord, 1 and 7. 7 is residuary. And now, if my lords kindly see the work order also, Milord, what was supposed to be supplied under the work order in question was, Milord, metal, steel, heavy melting scrap. Page 28. And that is what, Milord, they allege was delivered. Now, Milord, under the proviso to section 8 of the 2006 Act, Milord, there is one more rider. Milord, clause B says, clause B of the proviso says, an industry engaged in manufacturing those items, then there is a conjunctive and it says, before and rather, having investment in the plant and machinery of more than 1 crore but not exceeding 10 crore. There is one more condition, indicated there. So an industry engaged in the manufacturing activities which fall under first schedule to the 1951 Act, and the industry which has made investment of an amount between 1 crore to 5 crore.
10.
1 crore to, yes, I stand corrected. 10 crore. I stand corrected. Now, if my lords look at page 26A, when they applied, they indicated an investment of 20, an amount in excess of 25 lakh. But I must indicate that also. The investment is indicated at the bottom of page 26A. Total net investment in plant and machinery or equipment is the sum in slightly in excess of.
How is a small scale industry?
I'll take your lordships to that also. So, this was the investment made when they applied for Uddam registration. The clause B of the proviso to section 8 speaks about an investment made in present time. That is how I have read clause B of the proviso. An industry engaged in an activity which falls under first schedule and where as on today the investment is between 1 crore and 10 crore. If that be so, then he has to apply for a memorandum. When I set up an industry, I might have invested 25 lakhs of rupees, but then I improve on that. I make further investment, and if one day the investment exceeds 1 crore, it becomes mandatory for him to apply for registration under section 8 of this 2006. That is how I have read it, of course subject to correction. Now, if my lords kindly come to section 7, apropos to the query that has fallen from my lord Justice Rai. Micro, small and medium are defined there. Those are in terms of the investments made. The quantum of the investment made while setting up an industry. May I place section 7?
What?
Notwithstanding anything contained in section 11B of the 1951 Act, the central government may, for the purpose of this Act by notification, and after having regard to the provisions of subsection 4 and 5, classify any class or classes of enterprises, whether proprietorship, Hindu undivided family, association of persons.
Yes, Mr. Banerjee, 25 lakh to 5 crore.
So, even a micro enterprise may be required to mandatorily apply for memorandum registration under 2006 Act if the investment exceeds 1 crore. So it's not that only because I am a micro enterprise, I am not under any obligation to apply for memorandum or for registration under 2006 Act. Even if I micro, there may be a statutory obligation cast on me, and that would depend on my today's investment, which was never disclosed by my learned friend's client before any forum. So, for such an industry, in my humble understanding, a registration was a must. Unless he indicates what is the quantum of investment today, there should be a presumption against him.
But Mr. Banerjee, doesn't the proviso in section 8
yes,
make a distinction between a small scale industry and an industry engaged in manufacture or production of such and such?
It does.
There is a
It does.
classification, therefore a small scale industry may not fall under B if
Milord, may I, Milord, think aloud?
because
Milord, what
industry
if
was the set, was the universal set, of which small scale industry was a subset.
subset?
Then
But-
in that case, your argument will apply.
But what if a small scale industry has made an investment in excess of 1 crore and is engaged in an activity that falls under Schedule 1?
No, if a small scale industry is one, because the definition which you showed was of a small enterprise.
True.
The legislature uses the word small scale industry
Yes.
in section 8.
Milord, I was, Milord, reading these two
Small-scale
expressions interchangeably.
in the Industries Development and Regulation Act 1951, which you just now showed.
Yes, Milord.
It says that whatever may be there in section 11A, if you see there,
Section 11.
section 11B,
Yes. But it starts with a non-obstante clause, so Milord, we may not be required to look into 11A and 11B here.
it starts with non-obstante clause. That is why I say that section 11B becomes important there, because B is bypassed by this. So B was a different class.
True.
Now this different class is noted again as a class when you see the proviso to section 8, small scale industry and industry. Otherwise it would not have made sense.
Yes. Yes. Then, Milord, what would happen? Milord, may I, Milord, ask this to myself? What would happen to a small scale industry? Milord, small scale is defined, Milord, under section 7 to mean an enterprise, Milord, that has invested.
No, small scale is not defined. It's small
Small enterprise is defined, Milord.
Small scale industry is one which has obtained registration as a small scale industry prior to the coming into force of this act.
So, my lord is not reading, Milord, these two expressions interchangeably then.
No, that is
Wait.
what my prima facie reading of the statute is.
Milord, I read it, Milord, interchangeably. I may be, Milord, wrong.
No,
Let us, Milord, read it the way my lord is reading this. Let us read it in that way only. Then, Milord, may I?
Yes, difference. They are not the same.
Otherwise,
Advisably দু রকম expression.
এখানে দেখুন, এখানে বলছে small scale industry.
Small enterprise, correct.
And industry. Therefore, there are two. That is why you join the two.
Yes, correct.
Industry, small scale industry.
Correct.
Industry may not small scale.
The provisions, the way my lord has, Milord, read it. Milord, if there is a small scale industry which falls under first schedule of the 1951 Act, and Milord has today made an investment, Milord, in excess of 1 crore but less than 10 crore, Milord, to my understanding, Milord, then that kind of an industry, Milord, would fall under clause B and not under clause A. That's, Milord, how?
That is one way of reading it.
Because small, Milord, I say, Milord, B is again then a subset. For those eventualities, B would be again a subset of A. But that's how, Milord, Milord, was reading this. Otherwise, Milord, for all the small scale industries, Milord, this should be optional. But that was possibly not the intention of the legislatures, because, Milord, clause B is very specific. It says any industry who has made, Milord, this much of investment and is engaged this kind of a business must get itself registered.
But then that reading makes clause A absolutely a null and void clause. Because if any industry, then small scale industry other than those which are mentioned there in clause B would have made sense. Small scale industry would be inclusive of those small scale industries also, which are industries within the meaning of the...
Milord, the other small scale industries who are not involved in these kinds of activities, Milord, they won't fall under B. For them, Milord, A would apply. Milord, that would be possibly, Milord, the only way to harmoniously, Milord, construe A and B. To keep, Milord, both of them alive and give them, Milord, the fullest meaning.
Yes, that can be a way.
If, Milord, I read it in that way, then, Milord, this was a statutory obligation cast upon them which they have fulfilled but after entering into the contract. And if that be so, then my lord, Shilp Industries, Gujarat, my lord, every judgment is staring at their face, says unless you are registered before entering into the contract, you cannot approach facilitation council. But my lord, there is a single bench decision of our honorable court which is against this proposition. My lord, may I also show that to you?
Justice Bhattacharya.
Yes. My lord, this is possibly the only decision that is against this proposition. Nare, Anupam Justice. Kindly, my lord, turn to paragraph 11. My lord, 8-10 lines above, my lord, paragraph 12. Towards the right hand side, my lord, the sentence starts like a single bench decision of Gujarat High Court in Anupam Industries. Around 8 to 10 lines, my lord, from above, my lord, paragraph 12.
Yes.
A single bench decision of the Gujarat High Court in Anupam Industries Limited, etc., follows Bombay High Court decision in JSW Steel, which, my lord, we have relied on. The court was of the view that the Facilitation Council can have jurisdiction only where the supplier is registered under Section 8 of the Act at the time of transaction. These cases do not assist the petitioners for answering the preliminary question of maintainability. The decisions are more on the entitlement of a party to a dispute being identified as a supplier under the Act. The petitioner's contention with regard to Facilitation Council not having jurisdiction for lack of registration of the respondent as an MSME unit should next be dealt with. Section 2N defines supplier, which has filed a memorandum with the authority referred to in Section 8(1) of the Act. The petitioner's objection to the respondent number 2 being a supplier would appear from an affidavit filed by the petitioners, where it has been stated that the respondent number 2 applied for Udyog Aadhar registration in 2017, which is 4 years after the transaction. The petitioners have hence alleged that the respondent number 2 was not a supplier as on the date of the transaction. The admitted fact, however, is that the registration under Udyog Aadhar was introduced by central government in 2017, which was further changed to Uddam scheme from 1st July 2020. The respondent number 2 is registered under the Uddam scheme, which would appear from the records. The records would also show that the respondent number 2 applied for an MSME unit on 29th May 2008 before the District Industry Center, like Millard in this case. District Industry Center, Kolkata, which was long before the transaction between the parties. The District Industry Center, Directorate of Cottage and Small Scale Industries, that is the authority who granted them registration also in our case, was the notified authority in the state at the relevant point of time. Even otherwise, according to the learned counsel for the parties, the admitted fact is that the petitioners have already made part payment of such and such rupees. In maiden craft, may I skip over this? The above facts persuade the court to hold that the respondent number 2 was statutorily entitled to make a reference to the council for adjudication of the disputes. So, Milord.
Deprived of the benefit. Makes sense. তুই সেই ভিউটা কি এখন নিতে পারবি? If there is earlier cases of equal strength, consider. তাহলে you can follow them. Consider না করলে different. শিল্পী টিল্পি সব
হাতে রাখ।
চিন্তাই করছি Yes.
But Shilpi, Vaishyo Enterprise, Nitesh Estates, Gujarat State Civil Service says otherwise. Those I have relied on already. I have indicated the paragraph.
But
Says,
just
Those have not been considered.
no. No. Shilpi Millard was considered. Shilpi was considered. The others were
no,
not.
the latest one, Justice Narsimha's judgment, that considers all the earlier cases.
But Millard not shown Justice Khanna's decision.
Which is which
Because
one?
Millard, Justice Khanna's decision came in Millard. Came on 22nd January 2025 and Justice Narsimha's decision came on 10th January 2020.
For it, then Justice Khanna was subsequent.
Subsequent.
Then
subsequent. This is Justice Narsimha's decision. Joshavi kache ache?
That NBCC, that is
NBCC.
Narasimha. I had given a copy. The NBCC limited?
Okay.
It.
Kindly take paragraph 25 onwards.
As a?
25 minute of the report.
Yes. I have also relied on the same paragraph, 25.
And this is against me, so I'm showing this.
25.
Yes, ma'am. Possibly, in tune with my Lord Justice Bhattacharya's views. Somewhere, some. The question, paragraph 25 minutes. The question that we are called upon to answer is whether the reference to the Facilitation Council under Section 18 of the Act is impermissible if the enterprise is not registered by filing a memorandum under Section 8 of the Act before the contract is executed. This issue was not formulated, discussed, and decided in any other judgment of this court, including the two substantive judgments under the Act, that is Shilpi and Mahakali Foods. In these two judgments, it is worth mentioning such an issue was neither formulated nor discussed. We'll explain this in detail while discussing the facts and ratios of these judgments. Then, Millard, the discussions go on. Millard, the sections are quoted. Kindly, Millard, now state may come to দেখিয়ে দিয়েছে এগুলো মিলার প্যারাগ্রাফ 54 এটা তো মিলার প্যারাগ্রাফ 55 হ্যাঁ হ্যাঁ the জানিস তো
এটা আমাকে as on date amount মানে
হ্যাঁ আমি বললাম যে এটা তুই দেখাচ্ছিস যেদিন অ্যাপ্লাই করছিস আজকে তোর ইনভেস্টমেন্ট কত
2022
আধ ঘন্টা
আধ ঘন্টা হলো 2022 ডেটে তাই তো? তাহলে ঠিক বুঝেছি কামিং ফ্রম
কতক্ষণ দাঁড়া আচ্ছা বের করে দাও যাই জোরে Pilots are looking at minute NBCC. Minute before coming to paragraph 52, pilots kindly take paragraphs 37 to 41. Those are minute the reasons minute of this judgment. paragraphs 37 to 41, which are, my lord, staring at me. The Honorable bench was, my lord, of the view that, my lord, section 18 says a party to a dispute can approach. So by saying party, one does not necessarily mean that it has to be, my lord, supplier. Any party to a dispute, meaning thereby a dispute between an enterprise and a buyer and a purchaser, can also be taken to the Facilitation Council. That's how, my lord, section 18 of the 2006 Act was read, my lord, by this Honorable bench. And then, my lord, paragraph 55.
Between the two of you, you will take up till recess.
My lord, for me, it will take not more than 10 to 15 minutes.
15 minutes for you. How long for you?
Then I will take half an hour, my lord. We have to deal with
Half an
this.
So 45 minutes, Mr. Mukherjee, they say. Oh, all right.
Says more space.
All right. Carry on.
Paragraph 55, my lord, in this context, it is also important to note that as an institution, our Supreme Court performs the twin functions of decision making and precedent making. A substantial portion of our jurisdiction under Article 136 is reflective of regular appellate disposition of decision making. Every judgment or order made by this court in disposing of these appeals is not intended to be a binding precedent under Article 141. Though the arrival of a dispute for this court's consideration, either for decision making or precedent making, is at the same tarmac.
You're reading paragraph 37 of NBC?
No, 55. 37 and 38, my lord, are the logic. Given. Saying that, my lord, any party to a dispute can refer.
Yes, sorry.
55. I'm sorry, my lord, my mistake. In this context, it is also important to note that as an institution, our Supreme Court performs the twin functions of decision making and precedent making. A substantial portion of our jurisdiction under Article 136 is reflective of regular appellate disposition of decision making. Every judgment or order made by this court in disposing of these appeals is not intended to be a binding precedent under Article 141. Though the arrival of a dispute for this court's consideration, either for decision making or precedent making, is at the same tarmac, every judgment or order which departs from this court lands at the doorstep of the high courts and the subordinate courts as a binding precedent. We are aware of the difficulties that the high courts and the subordinate courts face in determining whether the judgment is in the process of decision making or precedent making, particularly when we have also declared that even an obiter of this court must be treated as a binding precedent for the high courts and courts below. In the process of decision making, this court takes, etc. Then, my lord, the matter is referred to the larger bench. Taking into account the compelling, paragraph 56, towards the end of paragraph 56, taking into account the compelling need to ensure clarity and certainty about the applicable precedents on this subject, we deem it appropriate to refer this appeal to a three-judge bench. And that reference, my lord, so far as my knowledge goes, is pending. Now, my lord, whether I ought to have, my lord, deposited, my lord, 75% of the awarded amount as a condition precedent. Oh, sorry.
Yes.
My lord, a further question arose, my lord, was raised by my learned friend that, my lord, my section 34 application should not even have been entertained and should have been discarded at the very threshold because, my lord, my application was not accompanied by, my lord, a deposit of 75% of the awarded amount. My lord, the language used, my lord, in 2006 Act is that a section 34 application shall not be entertained. It doesn't say it shall not be filed, first. Secondly, my lord, Since 2006 Act also says that, my lord, every conciliation, every arbitration under the 2006 Act shall abide by the provisions of the 1996 Act. My lord, if there is an award which is a nullity, which is a product of fraud, my lord, I am not required to make any pre-deposit under Section 36 of the 96 Act. There is, my lord, an exception carved out, which equally applies, my lord, to an arbitration, to a conciliation of under, my lord, the 2006 Act. And thirdly, my lord, there was a 36 application moved where, my lord, on contest and entry, my lord, an order was passed saying that my 34 application would be heard and disposed of without requiring me, my lord, to make any pre-deposit. And that order was never under challenge. That order I have annexed to my notes of submission at page 25, which was never under challenge, which was accepted by my learned friend.
Order dated?
That was order dated 21st May of 2024. Page 25 of my notes of submission.
21st May?
2024.
এই নোটটা কোথায় ওনার এটা নোট It's
25 minutes. And this interim order was extended, from time to time and was kept alive till disposal of 34 application. On the last occasion, one more query fell from your lordships, whether Arbitration and Conciliation Act would apply to conciliation also, before the Facilitation Council, because my lords were reading shall then apply, to mean that 96 Act would apply only to arbitration and not to conciliation, possibly. My lords will kindly take the trouble to once again have a look at the unamended provisions of Section 18, because under the amended provisions, mediation has come. Before that, it was conciliation. Can you take the unamended provisions of Section 18 once more? Subsection 2 of Section 18 of the unamended Act. This conciliation, and this arbitration was guided by the previous law before amendment. Subsection 2. On receipt of a reference under subsection 1, the council shall either himself conduct conciliation in the matter or seek the assistance of any institution or center providing alternate dispute resolution services by making a reference to such an institution or center for conducting conciliation, and the provisions of Section 65 to 81 of the 96 Act shall apply to such a dispute as if the conciliation was initiated under Part 3 of that Act. So, this applies to conciliation also, and 65 to 81 includes, Section 80, which debars a conciliator to act as an arbitrator. And that is what is held by Justice Sanjeev Khanna's bench, Honorable Justice Sanjeev Khanna's bench. ওই তামিলনাড়ু।
When conciliation in this case was being held, then
By the same persons.
the unamended act was applicable.
Yes, yes. Because my lord, under the amended provisions, it's now mediation. And in our case, it was conciliation. And then my lord, subsection 3 of the unamended section 18, where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the disputes for arbitration or refer it to any institution or center providing alternate dispute resolution services for such arbitration, and the provisions of the 96 Act shall they, here my lord, it says shall then apply to the dispute as if the arbitration was in pursuance of an arbitration agreement.
There are two parts. The Arbitration and Conciliation Act shall apply, and
conciliation
sections will apply to conciliation.
And my lord, 96 Act, lock, stock and barrel would apply to arbitration. 65 to 81 to conciliation. The whole act to my lord, arbitration.
80 says conciliator can't be arbitrator. And there is no dispute in this case. The conciliator.
No dispute. The same persons. Same persons. Now, my learned friend argued that my lord, 2006 Act is a special legislation. 96 Act is my lord, a general legislation. But 96 Act my lord, underwent an amendment in 2016 when the so-called special legislation was there. Still, my lord, no exception was carved out. So, my lord, when there is, my lord, an amendment carried out in a so-called general legislation, keeping in mind, my lord, there is a special legislation and that is kept unaltered. My lord, this is the my lord, amended provisions of general law which would prevail over, my lord, the special law. My lord, we have relied on two decisions on, my lord, that proposition that my lord, I have cited, my lord, on the last occasion. My lord, I may just indicate. My lord, one is at pages 178. No. Oh, I'm sorry, my lord, page 97 of, my lord, my notes of argument. And my lord, the other one is at page 132 of my notes of argument. The paragraphs I have also indicated. My lord, I formally cited on the last occasion. My lord, if there is an amendment in the general law after, my lord, when there is a special law already in force, then my lord, the amended provisions of general law would, my lord, supersede. And my lord, I have also shown, my lord, the bias, my lord, which, my lord, percolated into the process of arbitration because of
pointed out. Yes. You did not do this, you did not do that.
And my lord, Jharkhand Urja says this kind of an award, my lord, is a nullity. Because, my lord, with a preconceived mind, the conciliators are acting as arbitrators and, my lord, are carrying, my lord, the notions that they generated, my lord, in course of conciliation proceeding. So that is a nullity. That's what, my lord, Jharkhand Urja says. And Justice Sanjeev Khanna's, Honorable Justice Sanjeev Khanna's judgment is based on, my lord, Jharkhand Urja, which is not taken into, my lord, not taken note of in, my lord, Justice Narasimha's decision. So, my lord, this is the situation today.
No, there are multiple issues that I'll have to answer. I will try my best to streamline it for your lordships as much as possible. But there will be some judgments. I have.
May I have my lords kindly?
Yes. I have one copy, so my lord, I will provide it again on the if this matter another day. You know, the first issue, if lordship will take up my written notes. There was no direction for.
লিস্টটাকে সরাতো।
And I'll deal with the conciliation and arbitration issue first. Then I will proceed. Not here. I was reading Jharkhand Urja. Now, on the conciliation, my lord, we are relying upon the unamended, the previous MSME Act. Now, my lord, I have in my note indicated Section 18 along with the rules, my lord, Rule 4 and Rule 8. Together, my lord, if the rules are read with along with Section 18, it will be clear, my lord, that the intention of the legislature was that the conciliator can act as the arbitrator. In fact, my lord, these rules also do not indicate that Arbitration Conciliation Act will apply only when a conciliation is taken by, when the conciliator takes up the conciliation proceedings. But it is my understanding of the law that this is a beneficial legislation and also a special law. So when the legislator is using the language that conciliator can take up conciliation either by itself, after conciliation terminates, it can take up arbitration by itself, and thereafter, if the parties decide to refer it to an alternative dispute resolution body outside of the facilitation council, the Arbitration Act should be made to apply in order to ensure that there is no bias, in order to ensure that there is compliance of the Arbitration Act, because, my lord, the Facilitation Council has been given the liberty to conduct arbitration in terms of MSME Act in their own manner. It is that they have their own time-bound process. There are the issues before concerning an MSME would be different than a regular commercial arbitration. So the intention was to purposely separate the role of a facilitation council conducting arbitration and a role of an alternate dispute resolution body conducting arbitration. When the question was an ADR body conducting arbitration, it was necessary that the Arbitration Act would apply. This interpretation, my lord, has seen more permanence in the amended MSME Act, where, my lord, it says that subsection 4 of section 18, my lord, where the mediation initiated under subsection 3 is not successful, the term conciliation has been replaced with mediation and stands terminated without any settlement, which is the same as the previous act between the parties. Council shall either itself take up the dispute for arbitration or refer it to any institution or center providing ADR services for such arbitration, and the provisions of the Arbitration Conciliation Act shall then apply to the dispute. My lord, it had fallen from your lordship that the word then had been included in the amended act because, my lord, there was this dispute, there was this lack of clarity in the previous act that whether a facilitation council and an ADR is to give services or, my lord, conduct arbitration in the same manner. The presumption of the legislature, my lord, the presumption of the law over here is Facilitation Council is given all independence, which is why, my lord, section 23 of the MSME Act also says that these provisions will override, it is an overriding clause over any other law in the time, for the time being in force. The intention is to give the Facilitation Council as much autonomy as it requires in order to ensure that the purpose and object of the MSME Act is subserved. And the only exception has been carved out when the arbitration is referred to a third-party body. There, my lord, the rigors of MSME Act will not apply. There, my lord, the chances of deviation from the law are also high. There, my lord, we do not know how an ADR is going to conduct, and therefore, any third party is not given the autonomy like a facilitation council is. Therefore, the Arbitration Act is being made applicable to that body. And that has been further enabled by the change in the language in the amended act of MSMED Act. My lord, my learned friend has said that the proposition, my lord, he has relied upon that the general amended act will supersede, shall apply over a special law. My lord, when Arbitration Act also underwent an amendment, it was therefore necessary to amend the MSME Act. So the special law here has also undergone an amendment to make it in consonance with the amended general law, which is the Arbitration Act. My lord, this is my first submission. And, my lord, if lordship sees even the previous act, the rules, my lord, Rule 4 and Rule 8, I have relied upon. Lord, procedures to be, it is very elaborate, my lord. They've set it out very elaborately. Procedures to be followed. This is the MSME rules of MSME Rule 2006. Rule 4 says, council shall either itself conduct conciliation in each reference or application placed before it, or seek the assistance of any institute or center providing ADR for conducting Arbitration Act. And the provision shall apply to such reference. Lord, kindly seize the word to such reference. as if the conciliation was initiated. So it is when the assistance is sought for by a different body, Arbitration Act is made applicable. And my lord, the use of the word again in Rule 8 also, arbitration. Rule 4 is for conciliation, Rule 8 is for arbitration. Council shall either itself act as an arbitrator for final settlement. If the intention, my lord, was to separate the conciliation and the arbitration, as my lord, it had fallen from your lordships again, my lord, I have benefited from the observations fallen from the bench. There would not be a 5-member tribunal. There would be some disparity in the number of members.
Yes, Mr. Judge.
My lord, if I go through the other provisions of the Act as well, my lord, apart from Section 18, which explicitly says
Yes. Yes.
Apart from section 18, which specifically uses the word shall either itself conduct, I'm going through, my lord, golden principles of literal interpretation. There is no purposive construction required here. The literal interpretation says that shall either itself conduct. The use of the word shall is very clear. And in absence of any other word in the unamended act saying that arbitration will apply to the provisions of section 65 to 81 will apply even to the facilitation council, and my lord, read with the subsequent amendment which segregates that Arbitration Act will apply only to the arbitration conducted by a third-party arbitration body. Together, my lord, these three things, my lord, indicate that the conciliators are in a position to act as arbitrators. They have their discretion, and the discretion has been vested in them in order to fully give effect to MSME Act, which would, my lord, not have the rigors of the Arbitration Act, in fact, because Arbitration Act has its own timelines, it has its own parameters, its own the time-bound processes, it's whatever, my lord, the requirements under the Arbitration Act are, may not strictly apply. And my lord, my learned friend has also indicated that in arbitration, the statement of defense had to be filed. It is under section 21. The pleadings have to be filed within a time-bound manner, my lord. That, my lord, in fact, in this case, it has gone far beyond it. If, my lord, the records of the case will indicate that they've taken three chances the three chances were given to them to file the statement of defense. That has resulted in a lapse of 1.5 years. And on the last date, my lord, when they came and they sought to file the statement of defense, they asked for another adjournment on the last occasion, which was the third occasion. Then they again sought for an adjournment when, my lord, the council held that no further adjournments can be given. In any event, my lord, the timelines under the Arbitration Act was not followed. In fact, it was extended. It was far extended by the council. It went up to 1.5 to 2 years. My lord, I have the dates. I had given a one-page note on the dates, my lord, on the relevant dates when the pleadings were filed. Lordship will find it from that date, my lord, when the notice was issued to them, on which dates they have appeared, on which dates they have given their they sought to file their statement of defense. It will indicate therefrom, my lord, that they in fact did not follow the timelines of Arbitration Act as well. So it has gone much beyond it, and which is why the council decided to pass an award. So, my lord, the element of bias, my lord, may not hold true in view of the, yes, my lord, I think it is that one pager note. It is. I have given a copy of that, my lord, to my learned friend. Lordship takes up, my lord, arbitration, not conciliation held, my lord. Kindly seize the dates. That, it is a 2-page date note. Yes, my lord. Kindly seize 11th January 21. Both sides were present. These are all I have indicated the page numbers. Lordships can tally with my stay application. 11th January 21, both sides were present. 19/4, both sides were absent. My fault as well. 23rd June, respondent buyer was absent. They were absent. Ultimately, 13 July, conciliation terminated as buyer did not take steps to settle. And my lord, at page 40 is the notice where I was duly informed. My lord, they were duly informed that the conciliation has failed. And my lord, going in, taking steps in furtherance of the act, my lord, which in fact, my lord, in Jharkhand Urja is a case where factually the facilitation council did not take any further steps after the conciliation terminated in Jharkhand Urja. And my lord, the buyer argued that they were not given any opportunity of being heard in the arbitration because the arbitration never commenced. Hence, the whole proceeding was set aside. It, in fact, does not deal with an issue of whether a conciliator can act as an arbitrator, Jharkhand Urja, which my learned friend is relying upon, which subsequently has been dealt with by Sanjeev Khanna judgment, my lord, where Tamil Nadu says that Jharkhand Urja was not considered by Mahakali and therefore it has been referred to the larger bench. But Jharkhand Urja, my lord, I have gone through the entire judgment. Factually, the question is not whether an arbitrator can deal with as a conciliator can act as an arbitrator. In fact, lordship, it one paragraph, my lord, I will provide the copies, my lord. This was not with me. In fact, my lord, if I may just permitted to read one paragraph, it says, only on the ground that even after receipt of summons, the appellant has not appeared, the council has passed an award. So, my lord, what happened over here was conciliation was terminated. Thereafter, arbitration never commenced. And the buyer did not get an opportunity to even participate in the arbitration proceedings, which is why the entire proceedings was held to be a nullity. And the Honorable Supreme Court has held, in reference to section 18, it says, the said section itself makes it clear that when the arbitration is initiated, all provisions of arbitration and constitution will apply. And my lord, then it comes to say at paragraph 14, from a reading of section 18 to 18.3, it is clear that the council is obliged to conduct conciliation for which the provisions of section 6581 will apply, as if conciliation was initiated under part 3. Now it goes on to say the council is empowered either to take up arbitration on its own. The council is empowered either to take up arbitration on its own or to refer arbitration proceedings to any institution as specified. It is open to the council to arbitrate and pass an award after following. It does not say it must follow. Even Jharkhand Urja does not say it must follow. One, my lord, this question was not even an issue before the bench, whether whether conciliator can act as an arbitrator. Even as an obiter, they have said that it is open for the council. It does not indicate that it must follow. So therefore, my lord, Jharkhand Urja does not help at all. Even if this has been considered by, my lord, the Tamil Nadu. But even if it is considered subsequently that Mahakali did not consider this, it has been held, my lord, even by some Calcutta High Court judgments as well, my lord, that this issue was never a part of this judgment, whether a conciliator can act as an arbitrator. Now, my lord, if lordship will come back to my page once again, my lord, I deviated from it. If lordship sees arbitration 5 sittings held, my lord, I'm trying to rule out the question of bias over here. My lord, that 1-page note, my lord, I had given on 2 pages note, my lord, on the dates. Yes. My lord, it says 8th March 2022, petitioner present, buyer absent. 24th May, petitioner present. Petitioners, my lord, I am the petitioner. This was the, my lord, before the council. Buyer absent. My lord, kindly sees 27 July, buyer is present. First, my lord, they appeared. They were asked to file the statement of defense. 10th January, buyer is present. Second opportunity to file their defense. 13th July, buyer present. Third opportunity when they asked for an adjournment, it was refused and order was passed. Award was passed. And Lord, kindly sees the dates between the sittings. It's May, then July, then January. It is not like a regular arbitration, my lord, where dates are usually fixed within a month. My lord, it is common knowledge that MSME Council gives very long dates. So like they had adequate time and knowledge to prepare their defense. And my lord, on the third sitting, my lord, when they again came to file their seek an adjournment, an award was passed. There is no element of bias over here. Lordships can go through the minutes, my lord, it will be very clear. Yes, reference was made to the conduct of the parties before the conciliation. Lord, I will not deny that. It is evident from the minutes. But that has no bearing on the fact that no opportunity was given to them. They had ample opportunity and time to file their defense. They did not. It may have, my lord, struck to the conciliator, my lord, because they were the same parties. It's the same council. They are aware of how the proceedings are on. My lord, which is why I say that the facilitation council has been given a different, they have been given a discretion to act differently from a regular arbitrator would. Lord, it is because under these circumstances, my lord, where these buyers are trying to elude the process, they are trying to evade whatever directions are there, and in order to protect the interest of suppliers, which is why the MSME Act has been carved out of a regular, my lord, a regular proceedings like, my lord, an arbitration or, my lord, even IBC, where a creditor is asking for money. So which is why the whole purpose is different of MSME Act, why we have to look at the sections differently. Now, this is my I have already explained to your lordship, my lord, about Jharkhand, Urja and Tamil Nadu, my lord. These judgments, my lord, I will provide a copy once again if it is already not there. It is there? It's there, my lord. Now, my lord, I will come to the supplier issue. Lord, on the last occasion, my lord, in fact, when I had started my arguments, my lord, I had taken your lordships to the language of section 8 and, my lord, section 2N, which is what my learned friend is also relying upon. My lord, I had relied upon my lord, 2N3. My lord, 2N subsection 3 is what I say I am. Any company, the supplier means a micro or small enterprise which has filed a memorandum with the authority and includes, well, this is very important, the word includes any company, cooperative society, trust or body by whatever name, registered or constituted. I am relying upon my prior registration. Therefore, my lord, I am a company which is already registered or constituted under any law for the time being in force. My registration is already there and engaged. And my lord, the language says supplier means subsection N means a micro or small enterprise which has filed a memorandum with the authority in subsection 1, section 8, comma, and includes. Now, my lord, the interesting thing, if lordship will take up page, my lord, P33, my lord, of my application. Yes, my lord. Inner page 8 of the impugned order. Inner page 8 of the impugned order, page 333. 333. It says the second paragraph, having recorded the submissions of learned counsels, this court is of the opinion that definition of supplier as is found in section 2N of the Act does not say that it means and includes. It is a misreading of the section. And then, my lord, the court goes on to say, if the wordings under the section that supplier means and included, etc., then the argument as has been advanced by the learned counsel could have been accepted. My lord, the learned court below is also with me in this arbitration that if the section had included the word included, then a question of prior registration would be there. But, my lord, with all due respect, the learned court below did not read the section 2N, my lord, or maybe, my lord, it has missed his notice. My lord, this is one of the first things that had struck me, that had he seen, in fact, my lord, it was incumbent upon the learned advocates appearing before the learned judge to point out that section 2N, in fact, does include the word includes. He is with me on this argument. That is the most basic argument that can fall from it, which has been, my lord, finally been upheld in NBCC. NBCC says the same thing. Because, my lord, upon reading of section 8, the use of the words at his discretion, it makes it clear that it could never have been the intention of the legislature to make it compulsory. If it would have been the intention, it would have in clear, explicit terms indicated so, which, my lord, does not fall from any of the sections. Whatever arguments, my lord, we are making before your lordships are interpretations that I am giving for my client and what my learned friend is giving for his client. There is nothing in the Act which makes it clear. And, my lord, the argument that Shilpi Industries and Mahakali has considered this, that is also not true. Shilpi Industries, my lord, as NBCC has also recorded that, Shilpi Industries do not deal with this argument, my lord, whether a prior registration can have any effect. In fact, my lord, the issue of whether a supplier needs a registration in terms, has to have a compulsory registration, was not an issue before Shilpi. Just like, my lord, whether a conciliator can act as an arbitrator was not an issue before, my lord, the Jharkhand Urja. And, my lord, interestingly, even Tamil Nadu Cements, which has said that Mahakali has not considered Jharkhand Urja, that also does not have an issue in question whether a conciliator can act as an arbitrator. The issue over here is whether the writ petition is maintainable from an order under section, from an award under the under the MSME Act. Lord, when these issues have not been dealt with, Lord, how can it be considered to be a binding precedent, my lord? And, my lord, today my learned friend has said that proviso to section 8, proviso B will apply for me because, my lord, I am allegedly an industry engaged in the manufacture of production. Now, my lord, it does appear from section, my lord, page 26, my lord, 26A. It does, my lord, it does appear from 26 A that I am a 25, 25 that I am a manufacturing of other articles. In fact, it says other manufacturing other articles at page 25, Lordship. Page 25 is my Udyam registration certificate. Major activity manufacturing. Now, my lord, manufacturing can be of everything. I do not have, my lord, the memorandum of association and articles of association with me today. My lord, I can produce it. I shall get back to your lordship, my lord. I will show that what their primary business is. My lord, although it says manufacturing is it has a wide amplitude of what can be manufactured by a company. And my lord, the second issue is, even if I am considered to be a manufacturer of, my lord, metal scraps, because that is what I have admittedly sold to the buyer. I cannot deny that I have sold it to them. My lord, my investment is not more than 1 crore. Therefore, my lord, proviso B will not apply to me. Even if I am a small scale industry, my lord, first I am a small scale industry with a prior registration, which is, my lord, I say my argument is clause A applies to me. Clause A of the proviso, a small scale industry obtained a registration certificate at his discretion. This is what truly applies to me. That is what my registration certificate also indicates, which is, my lord, at page 27. 13th December 1981 was my registration. And manufacturing processing of scrap processing. It says a scrap processing. There is no way of indicating whether it's a metal scrap or any other scrap. Now, these are things which are open to arguments and speculations. It is not born from the record as clearly as it is alleged to be. Now, my lord, even if that is considered, it is issued by General Manager, District Industries Center, Cottage and Small Scale Industries. And going by the Udyam registration, which is, my lord, as on 2022, I am showing an investment of 25 lakhs 20,000. And my lord, that is not more than 1 crores as per proviso B. And that puts me in under the category of subsection 7(1)(a)(2), a small enterprise where investment in plant and machinery is more than 25 lakhs, but does not exceed 5 crore rupees. So, my lord, in any event, I do not come under this. My lord, what my learned friend is saying that it is my the onus shifts on me, my lord, to show what my investment was. My lord, today my investment can be different. I have been in the business since my lord, actually since 1981. As on 2022, my investment was 25 lakhs. 2024, it could be more than 1 crore, but that is not relevant for the purpose of deciding my status as on the date I have applied for my registration. Therefore, my lord, this B does not apply to me at all. And, my lord, I will again reiterate what I had argued, my lord, that the use of the word discretion after A and B, which is for micro and medium, in subsection 1, and there is no use of the word discretion in C. Again, similarly for the proviso, my lord, there has to be, it is clear, my lord, the legislature did not intend to make it compulsory. Now, my lord, this issue is already before the larger bench. So, my lord, nothing can be determined as on date. My lord, I understand that, my lord. My lord, I will anyway have to defend my client and establish that he would still be a supplier. And, my lord, over and above all of this, lordship, the compliance under section 19, my lord, in all due respect, was not satisfactorily, my lord. That burden I believe, could not have been discharged. My lord, because there is, my lord, with my limited understanding and research, my lord, I have not come across a judgment which says that there is any exception to section 19. And if that were the case, my lord, I will again repeat my argument. If that was the intention of the legislature, my lord, then it would have indicated that Arbitration Conciliation Act will apply to the entirety of the act. It does not say so. The mention of provisions of Arbitration Conciliation Act applying to Facilitation Council is restricted to the portion where a reference is sent to a third-party ADR body. But any other section in the Act does not say that the Arbitration Conciliation Act will apply. In fact, if that were the intention, my lord, kindly takes up section 19. The language of the section, my lord, no application for setting aside any decree shall be entertained. So, there cannot be a situation that can contemplate that, my lord, the rigors of rather the exceptions carved out in section 36(2) of the Arbitration Act will apply. First, my lord, the question of fraud, whether he has been able to establish it. It has to be, it is something, my lord, that has to be proven. Before that could be considered, my lord, the learned court below has come to the conclusion that yes, there is a fraud. Why? Because you're not a supplier. Why am I not a supplier? Because the word included is not there. Of course, if the word were there, then you would have been a supplier, and then the question of fraud would not have applied, and therefore, my lord, the buyer would have to deposit 75%. So, my lord, all of this brings us to the point that, my lord, it was the intention of the act that a 75% had to be deposited. Arbitration Act, Lordship.
What do you say to his argument, Mr. Banerjee's argument that on the Section 34 application,
Yes,
the
we have not
court,
we have not
yes,
preferred an appeal.
you did not challenge the order of unconditional stay.
My lord, I believe, my lord, if the orders, they have all merged into the final order. And my lord, when I'm coming before an appellate forum, it all opens up, my lord. Lordships are entitled to
Is
look
Section
into.
19 a bar on the court?
My lord,
On the court to entertain
yes,
setting aside,
it is.
unless 75%
Yes,
is
it is.
deposited.
My lord, therefore, it is not necessary to file it, to deposit at the time of filing. But my lord, it was a bar. The entire proceedings would be a nullity because they could not have passed any order subsequently. My lord, that is also there, my lord. So, my lord, yes, ideally, my lord, I should have, but I'm taking, my lord, this is the High Court, my lord. It can look into any and all factors that have culminated into the proceeding under Section 34, my lord. This entire argument will actually fall on that, my lord, because the entire proceedings stand a nullity because several orders has been passed. And when I'm filing an appeal before your lordships, my lord, all orders are open before your lordships for challenge. Just because, my lord, I have not filed an appeal from one particular order does not preclude me from challenging at a final stage. my lord, Calcutta High Court also, the law is settled, my lord, that 75% deposit does not have any exception.
Oh, that's Justice Chandrachud.
No, my lord, not that, my lord. This is a 2012 judgment, my lord. It is a part of my written note, Goodyear India Private Limited. And that is, my lord, the mother judgment. That section 19 is compulsory. You have to make that deposit, otherwise the section 34 cannot be entertained. And in fact, my lord, in these judgments,
You have relied on a judgment of Justice Chandrachud.
Look,
On this point, it's compulsory, mandatory.
look, Chandrachud judgment, my lord, I do not.
Page 92 of your note.
Glycols.
Look, glycols is a different issue. My lord. Glycols is not on.
Paragraph 10.
Yes, my lord. Glycols is also there, which is subsequent. My lord, but my lord, the issue in glycols is before a larger bench as well. But that is a different issue. Whether writ petition will apply, writ petition will follow. I have relied upon it. Paragraph 9. Yes, my lord. Lord, I'm sorry, my lord. Glycols is also there, which says 75% is mandatory. And the other two judgments are on the proposition, my lord, that interest is also a part of this deposit. Because, my lord, my learned friend had said that he is willing to deposit 75% of the principal sum. But, my lord, these judgments also cover that interest is also a part of it. So, my lord, as on date, and my lord, Tamil Nadu, which is after glycols, has gone to the larger bench. But, my lord, Tamil Nadu will not hold, my lord, because this glycols is judgment. So, the law is clear in as much as glycol is concerned that 75% is compulsory. Even though that issue is not before the larger bench, but glycol will still hold being the earlier judgment. And Lord, yes, I have the other two judgments are on, my lord, the principal sum and interest. 75% includes both. It does not mean only that portion. And in any event, my lord, the proceedings will, again, my lord, it is a nullity because there has been no deposit. And if the question of fraud were to be considered, my lord, it is ultimately clear from the language of the impugned order itself that there was a misreading of the section.
This issue is also at large.
We at large. Yes.
One issue, my lord, my learned friend has not given an answer to, which I had raised, my lord, that is this, the section 34 also proceeded on the premise that the order was not stamped and therefore it was considered a nullity. Lord, I had relied upon the Supreme Court judgment, my lord, Onushua.
Don't worry about that.
Yes, my lord, that was not, that is also in my favor, lord, because that is not a ground under section 34 to set it aside. Lord, the primary issues would be the supplier issue. Lord, with my limited understanding, my lord, I believe this matter should be remanded to the learned court below, and they should be directed to pay their 75% deposit in order, if they want to proceed with an appeal, if they want to challenge the award. Lord, in view of the fact this order was passed on 13 July 23, I have not been able to, my lord, file my execution proceedings as well. So, Lord, I am a supplier. Lord, whether I can proceed with MSME or not, there is an award in my favor. And with that award, my hands are tied because there has been no deposit by the buyer. And the section 34 has proceeded on that basis, an entirely wrong basis. And now even before the appellate court, my lord, even before the appellate court, my lord, we had agreed that we will not press for any deposit, my lord, because my lord said, wished that we complete hearing of this matter. So, my lord, I believe, my lord, the best course of action would be to let them go back to the Learned City Civil Court. If they wish to proceed, let them make that deposit and we can fight it out fairly and urge all these points before the facilitation, before the Learned Court below.
And you can at least withdraw some money from there.
I can get some relief for my clients. And if they do not want to, my lord, then I have the liberty to proceed with execution as the law mandates.
That is
my lord, can I submit another written note, my lord, because my previous note does not consider any of the arguments.
When will you give us?
My lord, I can give it by Monday, lordship. Today is Thursday.
You give it to us by Wednesday, no problem.
Well,
we'll give you Wednesday or Thursday. next Thursday. We'll take your note.
Yes, my lord.
We will keep the matter immediately upon reopening for further hearing for the simple reason. In the meantime, we will go through the
Yes.
notes and judgments.
Yes.
We are likely to have some clarificatory questions. That is why. So this immediately it will be listed next Thursday for purpose of submitting your
My lord, my revised
additional
note.
written.
Yes, I will do that.
Do you want to make that a comprehensive note or an addition to the?
My lord, I'll make it a comprehensive note, my lord. In that case, my lord, this note, my lord, it will be
Yes.
confusing for your lordships
Correct,
also.
correct.
I shall do that. My lord, I'll include all my points now because I've also
Then why
gathered.
don't you take back this?
My lord, I will take it back. I shall take it back, my lord.
তাহলে তুই রেখে দে।
And আমরা দুজনেই বলি। My lord, if my learned friend is agreeable, we can exchange notes as well, my lord. If he
Yes,
would,
exchange notes.
we
But
can.
on the returnable date, will it exchange?
Very well.
Right.
List this matter once again on next Thursday, date the
25th, my lord.
আগে তার আগে বলে দাও, heard Mr. Banerjee, learned advocate, and Miss Chatterjee, learned advocate. Mr. Banerjee, learned advocate for the respondent, and Miss Chatterjee, learned advocate for the appellant. At length, stop. Paragraph. List this matter once again on Thursday under the same heading.
Grateful, my lord.
Grateful, lordship. Thank you.
কি চাও? হ্যাঁ কেন? 9 মিনিট সময় আছে তো।
অ্যাপিয়ার করছেন ব্যাংকে? হ্যাঁ
NSE.
Item 9 মানে I'm for the petition আমাদের।
No, did we hear this matter before?
No, my lord.
No, Mr. Bhattacharya, allow us to take up the matters which we have heard substantially. The next matter, I believe we have heard, Mr. Mitro, hiding behind somebody. You want to do it after vacation? No, Mr. Mitro. Acha. তাহলে আর কি শুনেছি? Indian Oil Corporation. Is he here, Mr. Shataru Banerjee?
No, he's in library.
Yours is adjourned then.
After vacation.
হ্যাঁ শোনো, বুঝতে পেরেছো কি বলছেন? Immediately after vacation, এটা 10 নম্বরটা।
One humble prayer. In my that one humble prayer, Mr. Mitra is also here.
No, don't ask us to make it partnered. We will not. Just hope for the best. We can't make all matters partnered.
Difficulty brought your lordship kindly appreciate.
No, Mr. Please don't request us. It's embarrassing for us. Let's hope for the best. That's all.
No, there's likelihood another division bench will also not be there in view of.
No, we don't know. We don't know what will happen tomorrow.
Because Lord, we have extensively, your lordship has heard Mr. Kundu. Lord, this side of the argument is over.
Yes.
So, Lord,
You will re-argue. That will give you good practice. On the request made, shall we record an order or just
so kindly record an order.
on the request made by learned advocate for the learned senior counsel appearing for the respondent, let this matter stand adjourned and be listed. Give us a date, Tarikh though. And be listed immediately after the Puja vacation on October 28. You will be back from France.
আমি কোথায় ফ্রান্সে তুমি যাচ্ছ?
Can it be on 4th, my lord?
Yes, November 4. 11 is other council here in 11.
I'm for the appellate.
Who was arguing?
I'm for the respondent.
Who was arguing?
Shatrugh Banerjee.
Hasn't he concluded? No.
No, Lordship.
Oh, he's not here.
He will be here. He was here.
Come back at 2 o'clock.
Lordship.
So far as item 9, my lord, your lordship please to take it up after vacation.
After vacation, unless you say there is huge urgency.
Old matter, my lord.
তাহলে 9টাকে করে দাও, after vacation করে দাও। চলো এবার আমরা ঘুরে আসি। Which one, Mr. Dhar? Yes.
Effectively, I am seeking, there is already an order by your lordship sitting in division bench. I am seeking that I am similarly situated. The only, and lordship has recorded the entirety of that with 3 questions. They answered all the answers in my favor. But there is no urgency.
Right, Mr. Dhar, we'll take up.
Yes.
We'll take up your matter, but after 11. If 11 does not happen today, then 12. So please come at 2 o'clock and see.
Yes.
Huh? We'll come back at 2 o'clock. What are you waiting for? Commercial. You're not waiting for a matter in the next court. Mr. Mukherjee was here. I thought he was waiting for a matter in this court.
May I pray for one indulgence today, my
Yes.
because I'll do the matter here in the morning. So, my lord, I requested Justice Kapoor to take all my matters from 2 p.m.
Huh.
Somehow, my lord, I couldn't read, my lordship couldn't, my lord, take up. Can we have this after the vacations, my lord? Because I have to only show that in the original, my lord, I have to go back to the.
Provided your friend agrees, we have no problem.
Is agreeable. This is just a point of law, so my lord.
Lekho, Mr. Banerjee.
In fact, on the reopening day, let me finish it after the reopening.
Keep it on the reopening day.
Yes, so that my lord.
But no, Mr. Banerjee, reopening
That
day
day
is a
everybody.
Friday.
Yes?
Is a Friday.
Oh, again, lordship will have other benches and all.
Thursday, I don't know. It'll
That
be
is
the
list.
list.
Yes,
It'll be the
let me
list.
do it on that day. I don't think that day much of the people would like to do matters, my lord.
Mr.
We'll finish
Banerjee, learned counsel appearing for the
respondent
requests that this matter may be taken up immediately after the puja vacation. Paragraph. Learned counsel for the appellant does not have any objection to such proposal. Paragraph. List this matter on October 24, 2025,
Great.
when the court reopens after the puja vacation.
Grateful, my deep pleasure.
I appear for the
Your other side, Mr. Thor?
Mr. Shumon Shengupto and Amrita Paja Moulik. In fact, they are aware. My learned friend has also sent by WhatsApp, and there is a remark.
All right.
But in fact, in order dated 3rd of May, the reason it was assigned before your lordship, when my lord, the matter was. The reason was when the matter hearing started before the other honorable division bench, the honorable division bench read lordship's order, which summarized my case as well as the respondent's case. And 3 questions were formulated by your lordships. Having seen that, the honorable division bench thought that it would be better that lordships. In fact, my lord, I don't want to make any submissions because whatever I had to say, that is there, lordships recorded in the order dated 3rd of May by your lordships. 3rd May 24. Yeah.
Third of May this year?
No, it was 24. But I have the separately. I have the photocopies also.
Yes, we have got it. উল্টো পাল্টা সাজানো সেই জন্য খুঁজে পাই না কিছু নেই এই ফাইলে কপি নেই 3rd of May না এই সময় কে ছিল আমার সঙ্গে
করে দিয়েছে স্টার্ট হওয়ার আগেই করে দিয়েছে আমার নেক্সট
এছাড়া তো দিতে পারবো দেখি তো এই কারেকশন গুলো করেছি নাকি করেছি ইনস্টলমেন্ট Ask your junior to give them another call because without them we can't really proceed. The questions are to be answered by them.
And in fact, they came with the answer. All the answers were 3 questions: whether the notification dated 8th October still operative, their answer, which they placed also, must be there in the file. But in any case, I have extra copies. They said, yes, it is still. Second question was, any policy decision of the state doing away with the practice contemplated under the answer was specifically no. Third question was, decision of the state government to put up the plot in land question in for auction. Answer was no. Yes, no, no. Well, she informed that she is coming. She was. কত তারিখে মিরাটা করেছে?
In Mira Sarkar.
May I just briefly say what I exactly want and whether it is permissible or not? My lord, the petitioners before your lordships is the widow and the son, because the person, my husband who filed the writ petition, he died in 2018. So thereafter, me and my son were substituted. The fundamental context of the case was, I gave, it was there, but just few dates. I just made it not a written note, just a basic dates. December 89, my lord, the offer of allotment that was made. These are all undisputed things, whatever I put it in. Then January 19, I accepted the offer. Now, there are three conditions. Three conditions in a sense, so far as the payment part is concerned. First was that 10% of salary to be paid. That was accordingly paid by my husband, and that was fully complied with. Second condition was 1/3 of the salary to be paid within 2 months. This was also complied with. Third condition was rest amount. This amount was about 7,000 and odd. That is to be paid by 1993. The fault of my husband was he paid it, but he paid it after a lapse of 6 years. So, and they received in June 99. But he was supposed to pay it by 93. That was the fault on my part. So remaining amount, that was third condition. So it was received in June 99. After receiving, my lord, thereafter when possession was sought by a letter, that letter was made in April 2000, next year. Thereafter, my lord, after 1 year, 7 months, they gave a letter. The subject of the letter was termination, but the body of the letter was that we are returning your money. Now they are interpreting that itself is a termination. In any case, writ petition was filed. When the writ petition was filed, my lord, in August 13, there was an order. Effectively, this order was what your lordships also indicated, that what was for this kind of cases, if someone is willing to pay the value, so that instruction was sought. Now 18, my husband died. Then my lord, March 22, that's the judgment and order of your lordships, where my lord, in case of Mira, a similar relief. I would not use it identical for two reasons. If I structure it, if there are 4 points, I would say in 3 points, I stand much better way. For an example, in the case before your lordships, in Mira's case, Mira was not even the original allotee, unlike my case. Second, my positive difference is that in that case, without being an allotee, he transferred it. In this case, nothing like that. But there is a point which could be difference and which I cannot say it's a positive on me. It can be interpreted to be negative on me. In that case, though it was an illegal, though it was not an allotee, neither there was a proper sanctioning anything, construction was made by someone else, and that's Mira. In that light, lordships wanted to know, is there any notifications governing in the field that though that time it was, in my case, 7,000, there must be enhanced amount. So they came up with the instructions that there is a government notification of 2010, wherein if calculated, I find that now that 7,000 comes about 16 lakhs. The bone of contention is that the respondent state, they are not against that myself getting that land. They are saying you have to pay 59 lakhs. The basis of these two is this: if lordship judgment and the applicable notification is to be followed, then I am supposed to pay 16 lakhs. But forgetting everything, if it is to be treated like a market rate for any transfer from the ADSR calculations, like not a government lease, not lease this kind of allotment, like any normal melody, there is a rate chart for purchasing a land, then it will be 59 lakhs. So that is the bone of contention. Now, my contention was that I could have understood that your lordship's order was not complied with, questioned, and not only your lordship's order, there was another division bench order, and timing is also almost same. The Mira order was complied with almost in the similar timing when I am seeking my lord the relief.
Give us Mira's order.
Yes, my lord, that is annexed at page 155. Yes, Captain. And my lord, one small thing, another positive difference in my favor, in this case, apart from the fact that the Mira was not even the allotee, Mira never challenged the terminations. There also, accepting one payment, Mira did not pay the two other payments. In my case, I made absolutely fine two payments. Third was also made, but that was delayed. Mira order complied. 158. 165.
Please cancel. Subsequent transfer. Correct. No. It's as per this notification, whatever the calculation. Notification calculate korle according to this notification. Market rate dhorle 59. $7,000 দেরি করে দিয়েছে। They are solely relying on Mira Sarkar, where the state had said that if Mira Sarkar, who was transferee from the original lessee, after the lease stood cancelled in 1974, 30 years later, there was a purported transfer. Anyway, the states accepted that if the salami or whatever transfer fee as per the notification number such and such dated 8th October 2010 is paid, then the state will execute a fresh lease in favor of Mira.
Correct.
And that was apparently done.
Yes, sir. Page 158, it was done.
Now, why not follow the same course of
May I
action?
just indicate only one thing? Milord? If your lordship reads the entire things, the transferee, then it is giving to the Mira. First the allotee, then it is going to the Mira. Here, Milord, the transferee was in the possession. The distinguishable fact is that Mr. Dhor's client was never in a position and not even complied the stipulated conditions. They never ever in the positions. That is why in the flux of the time, Milord, wait, please. For that reason, efflux of the time, that lease deed got cancelled. And this Mira's notification, which is fallen from your lordship, is not at all applicable because this is coming from in the Mira. The first transferee, then the Mira. Here, Milord, the allotee was the government of West Bengal. He was not at all in a position, could not comply the Milord mandatory provisions.
Allotee was government of West Bengal.
That's the opposite. Allotee
Yes.
was my husband.
Husband was there. I'm sorry, husband was there, but they could not in a position, not constructed, nothing.
We had asked you 3 questions
My
as
lord.
recorded in our May 24 order.
My lord.
Number 1, whether the notification is still in vogue. Your answer is yes.
Yes.
কোথায় গেল সেটা? No, answer দিয়েছি ওরা।
Yes, but they placed it.
Down, bhai.
Down. Yeah.
আমার বিপদ
Number 2, is there any policy decision of the state government doing away with the practice contemplated under that notification? You have said no, there is no such change in policy. Number 3, has that plot of land in question been put up for auction, or is there any proposal in that regard? Your answer is no.
My lord.
So if that plot of land is lying vacant, government should be interested in money.
Of course, my lord.
So why don't you take instruction if they are prepared to pay the salami in terms of that notification or any other notification that may be applicable according to you? Why keep it? Why just waste that land?
First of all, if your lordship sees this particular litigation is going on for a long time, we are interested only for the revenue.
Correct.
Today, Milord, if Mr. Dhor's client is ready to pay the market price in that event, which they are initially agreed upon, right? In that event, we can offer him, or else the initial decision was, Milord, since nobody was in the position and the prima facie, Milord, the agreement which was terminated between the Mr. Dhor's client and myself, it was efflux of the time terminated. So, Milord, we are on the opinion, so this has to be used in particular purpose by putting it on the auction. Now, if you participate on the auction, very well, or else if your lordship, in that event, what would happen? I just indicate only one thing, Milord. If I put it in the auction, in that event, it will be open for everyone, or else it will be a class within the class.
With interest. Yes. Bajudio successful. Yes.
Milord, the Mira's notifications is applicable. I once again repeat myself for the cost of repetition, Milord. This is applicable for the purpose of transferee. Here, if your lordship kindly take trouble to see page 97 once.
Mr. Sengupta, we are on a simple point. Forget about your nitty-gritties of law, whether this notification applies or not. You cancel the lease in favor of
Mr. Dhor's client.
Mr. Dhor's client, original client, who's no more.
Yes, yes, yes.
In 2004, the cancellation?
2001.
One.
Yes. And then-
Termination was in 2001.
Yes.
For the last 24 years, you have done nothing with the plot of land.
Because there is an injunction related to that extent.
From whom?
Yes, from
We have
this court.
injuncted.
He was enjoying. Milord, I tell you, Lordship, this particular, because of these litigations, we could not settle the the land. This is number one. Second, when this matter came up before your Lordship, the specific question came from this bench, what would I do with this? My answer was, we will putting the same on the auctions. Then your Lordship's observation was that, kindly hold it for a month, then you will take a decision. It was initially.
Your written instruction is there is no proposal for auction.
It was for the may I just trouble for your Lordship once more. If your Lordship going by the Mira's notifications, Mira's notification not at all applicable here.
Forget about Mira's notification.
Very well.
Put it up on offer for auction. You're wasting property of the state.
I am ready to put it up, Milord. I am ready to put it up. There is a stay order, Lordship, kindly vacate that. I will definitely
Where
put it
is
up.
the stay order?
No, no, Malad, there is Lordship has. Yes.
Yeah.
Malad, there was an order of your Lordships on status quo. That was on the
I
first
see.
day.
Right. So I am ready to put it on the auction, Milord. No, wait.
Dependency of the rate. Dependency of the rate.
Malad, I.
Jani's the state government, any government for that matter, any statutory authority. Pending ache.
Malad, the apart from, because.
No, Mr. Dhor.
Yes.
Mr. Dhor. Firstly, he may be right that notification may not strictly apply in terms.
Yes.
Because there, in Mira Shorka, there was a transfer from the original allottee, Vato Krishnopal, to Mira.
Right.
Right, wrong, indifferent. And Mira made construction.
Yes.
In that background, and there was this notification which permitted the state to regularize by executing fresh lease in favor of the transferee upon payment of the whatever compensation in terms of that notification. That was done. Now here, A, you are not in possession, you have not made any construction.
True.
And B, this notification may, because you are the original allottee.
May I say this? I understand. Malad, in Mira, the termination was not even challenged. Unlike in my case, because I have not touched upon the merit of my case, I have challenged the terminations on the fundamental ground. If Lordships look at page 101, that I challenged, that itself was not even a termination. And that was the only document which was served up me. I wanted a shortcut. That's the reason. Kindly come to page 101.
On an overall reading, constructive reading, Mr. Dhar, let's not go
No,
here. On merit. You don't have, you defaulted for 6 years.
Well, I defaulted for 6 years, correct. But there are.
Go and deposit money in a counter.
Yes.
That chap accepts without knowing why you are paying the money.
No, may I say this?
And we have refunded it also.
But there are other cases, not only your Lordship's order being complied with, but there are other division bench, only because that, if it is a state, I can understand that if it is a
participate. They are saying they have not put it up on auction because of pendency of the writ petition number 1.
But they won't be able to afford that. That's the truth. The widow won't be able to afford it.
Then what can be
then
done?
Otherwise, my lord, they offered that 59 lakhs just like a that part is clear. It's not that state has not taken a stand. Because I took specific instruction, my lord, the widow and the son, they won't be able to afford it. Well, may I try to well, first I made an attempt if I can somehow sail through Lordships that order. That was my first attempt. It is possible that I may fail. It is possible. But there are other points. If Lordship kindly, may I just indicate the points? If Lordship feels that I have a better case, and I say, my lord, there are 2 honorable division benches orders and simultaneously.
What is the proposition laid down by the division bench?
Well, I would not say it's a proposition of law. I would not say that. I can't say that. I say it's a recognition of existence of notifications which regularizes if there is a fault clause on payment of money. And similar orders. I would not say this is really a law.
এইটা কোথায় মেমো এইটা
If lordships kindly have a look at in case of Mira also, my lord, the market value of Mira was 38 lakhs. Following the notifications, Mira paid 5,86,000.
Where is that notification?
My lord, that notification page 165.
অ্যাপ্লাই করে কি নোটিফিকেশনটা যেটা দেখি
12 জুলাই তো দাদা
What I understand, my lord, though their instruction that has not disclosed anything, what I understand that after the order of the learned single bench, now possibly they are trying to insist on a higher value. But in that case, my lord, the rules of the game having started, the matter being decided, that principles might come in my favor. But this is the notification. Page 165. And lordship may kindly look at page 158. That the compliance of your lordship's order, this notification was specifically mentioned also. 158 is the compliance.
Why will this not apply in this case?
Millet, lordship have seen Millet the notification over here. Kindly take trouble to see the first notification. I would like to point it out. In partial modification of the early, this is Millet 8th October 2010's notifications.
Yes.
Now, in partial modification of earlier notification such and such, dated such and such, in suspension of the such and such notification dated, number such and such dated, the governor has pleased to fix the rate of the salami and the rate of the transfer fees of the leasehold right of the such and such. So the nature of the Millet, the salami got changed. Now, what is Millet over here? The original notification. May I be permitted to place the same Millet? Just I read it Millet, then I will be Millet placing the same. Withdrawal of the restriction in compulsory minimum period of holding by the intending transfer and category of intending transferee or transferee of the plot at the Kalyani township issued by this department.
Give us.
My lord, kindly have a look.
Copy আছে ইনস্ট্রাকশনই আছে
আমি দিচ্ছি যে আমার একটাই ছিল আমাদেরই ভুল আমি তো জানি স্বীকার করছি তো
Lordship may kindly consider someone.
So give us 2007 and 2009. What are those?
These are the other two. This is I am also looking for the same. না না সেটা ঠিক আছে আমি দেখতে চাই যখন নিশ্চয়ই দেখাবো marked copy. General copy তো already annex রয়েছে
whatever was being paid, if that still itself did not have any could not have been only for transferees. The round do you accept this rule? How do you realize that? যার কাছ থেকে transfer হলো, how do you recognize this transfer?
এটাই তো আমাদের এটা
The way in which you have applied it shows that you are treating those transfers.
এটা এখন সেটা তো বললো যে আমি একটা ভুল
Well, there is another division bench order also. In an identical manner, they following the same notifications, they have taken the money, whatever was there in the notification of 2010. Another our division bench, that is a
there also it was the original allottee
he was the original allottee.
and there was default.
There was default and more default. But Lordship may kindly look at this. All I think is, I accept this difference that I have not made a construction, and construction is, of course, a very substantial point, is kind of rights. I agree with that. But at the same time, Lordship also consider a person who is following the law in a sense. I know that I cannot transfer. Unlike the Bhatto Krishna, he could not have transferred. He did not get the possession also legally. He did not even pay the second payment and third payment. He did not even challenge also the very transfer. Despite all this, just because he transferred, which he could not have done, kindly consider, my lord, that aspect. My instruction is, but that is nothing to do in the pleadings, that this variations in reactions of the state, they vary for some reasons. Well, very recently, there is a judgment of the Honorable Supreme Court where Justice Gawai, on a similar relief in similar kind of matters, Chandel. এটা কবে কমপ্লাই করেছে এটা? Lordship may kindly also consider that a transferee cannot get any better rights from the original allottee.
ঠিক আছে কিছু করার নেই
Well, page 174, last paragraph, that's the difference made by.
Is what other point do you have?
Yes, my lord, if I can just indicate, according to me, what is the incorrectness in the judgment of the learned single bench, that is page 174, last paragraph, and 175, first paragraph. Kindly have a look at, my lord, that portion.
Tell us.
Yes, my lord, there the learned single judge is recording that during course of argument of judgments of the honorable division being relied upon by the learned advocate for the petitioners do not come in any aid, since Mira Sarkar, the house was already constructed, and thereafter question arose for regularizations of the land, and in the backdrop of the facts are delineated in the order dated 25th March 2022. That's the Mira's order. The government notification dated 8th October 2010 was applied, which is not the fact situation of the present case. But if your lordships look at lordship's order, it is essentially not because you have done a house, that's why you are getting it. It is essentially, do you have a notifications of regularizing? If the answer is yes, then. Now, otherwise, lordship may kindly consider this. Then there is a gentleman who is the original allotee. Whatever rights he had, my lord, legally or illegally, he can only transfer that part. Therefore, Mira, yes, Mira could not have had a better right from the original allotee. My lord, my other point was that what I challenged was page 101. If lordships kindly have a look at 101, that is really not a termination at all. And they have come up with an affidavit. In the affidavit reply, they have given a 104. In 101, there is an proof of service. They have annexed that. But for 104, which can be said to be a termination, there was no proof of service. There is nothing they have been able to show that. And 101, which I challenged, it looks like that a termination, but if lordship reads the sentences, kindly have a look at 101, my lord.
We have seen, Mr.
Lordship
Dhar,
has seen.
the subject makes it very clear.
Now kindly
read the notice as a whole.
No, my lord, may I request, my lord, once more. All I say that the subject says the termination, but termination
Because
or
of the termination, the refund.
and no, my lord, all I say is that this is on 15th of January 2001. In that light, kindly have a look at 104. There could not have been 104. Had it been a termination, there would not have been any requirement of 104, which was never served on me. Because this is after that. 101 was on 15th of January. Kindly see. Now comes after that 22/1/2001, which was never given. Now there they indicate, second paragraph, and whereas in terms of clause 9C of the agreement for lease date such and Sri Mrityunjay Saha was under obligation to construct a residential building on the above cited plot within 5 years from the date. And whereas the possession was not taken over by Mrityunjay Saha. Now, in that light, my lord, I sought for the possession, that is at page 46. And it was, I did say that there was a delay of 6 years. But at the same time, there was a delay of 1 year, 7 months. After delay, when I made the payment, thereafter, my letter was page 46. So they really thought of not giving me the plot of land when I sought for the possession. 46.
একটা ডিফল্ট আর একটা ফাইল দিয়েছে কোম্পানি করতে থাকবে ও থাকবেই সব ইয়েতে অনেক করেছি ওই রাউন্ডেই অনেক করেনি বলে
And my lord, page 100 and
Where is this 5 years clause, Mr. Sengupta?
Will it Lordship kindly take trouble to see page 97 once? Will Lordship got it, will it?
Yes.
Now kindly see see will kindly take trouble to see from paragraph 3 onwards that we shall pay at least 1/3 of the premium or salary in respect of the said inclusive of the amount rate of such and such per kata within 2 months from the date of acceptance of the offer. In default, the payment as aforesaid of the 1/3 of the premium salary, we shall pay interest on the amount thereof at the rate of 6% per annum from the date of acceptance from the date of payment, and the should we default in payment of 1/3 of the premium salary as aforesaid with the
All
interest.
right, all right. Thank you. We have found it. You will never
No,
find it.
9C, I was entirely giving the picture.
101 did not say about the 9C. 101 said about the clause 3.
Mr. Shinguptu, 101 termination order, you are saying? Very well. We will construe it as a termination order. It might be construed, looking at the subject. Then you say we are returning the pay order. Right?
Yes.
And look at 104. We are forfeiting the amount you have paid so far. Earlier amount. Oh, I see. Earlier amount.
Earlier amount.
Earlier amount. Yes. Correct. Yes. No, Mr. Dhar. Sorry.
I have. Lordship, may kindly take my lord page 110. 110, I have taken a specific point that 110, my lord, from the top after 5 lines. My point was that 104, my lord, that is 22nd of January, that was never given to me. That was never given to me. Now, so if that is never given to me, then what remains is only 101, which I challenged. The moment I got it, I challenged it. Now, if Lordship look at 101 itself, there is a violation of clause 3. That is the payment part. You did not make the payment, agree in time. In that light, my lord, I am only
Also,
seeking...
admitted case is that you have violated 3C also. Construction.
My lord,
5 years.
Now, may I seek? When Lordship look at my page 46, my lord, page 46. May I just take?
You've tried your best, Mr. Dhar, as you always do.
No, of course, that's a part of.
We have to move on with other matters also.
May I just wrap up within 2 minutes? 2 minutes. My first minutes is that why I am seeking this similar relief, because of, my lord, there is a very recent judgment of the Honorable Supreme Court that Lordship kindly take Lieutenant Colonel Suprita Chandel, paragraph 14. My lord, this is judgment by Justice Gawai, 2024 SCC Online, SC 3664, paragraph 14. Referring to 24 SCC Online, SC 3664.
There was no declaration of law in our earlier division bench order.
Agreed.
Nothing whatsoever.
True. All I say that the similar way, Lordships did not declare any law. In the somewhat similar manner, Honorable Supreme Court also granted relief in 99 SCC 22. There was a default clause in Jasbir's cause case, my lord, in paragraph 4.
We can't exercise power under 142. Supreme Court can.
Well, I'm not seeking 140. Of course, it is. Lordships cannot. That's not available. All I say is that, well, state cannot behave like a private litigant. All I say this. Now, this is paragraph 4. Kindly have a look at. It's not a declaration of law, but without expressing an opinion on the question of law as raised in the appropriate to direct the regulation allotment of the site in favor of the appellant. So there was also a fault clause. And my lord, why I say this, that this has been done following lordship's order in Mira. This has been done in other division bench, and in 2021 20 SSC 419, my lord, in Granules India's case, the difference between state and the private litigant, state has acted. In that context, lordship may kindly consider paragraph 9, 21 20 SSC 419, paragraph, leaving 5 lines, 1, 2, 3, 4, 5. From the 6th line, little right hand side, the state cannot behave like a private litigant and rely on abstract theories of the burden of proof. The state acts through its officer who are given power in trust. So I'm only relying on this part, that state has acted. The other division, this I will conclude just showing this. The other division bench, my lord, similar, where the original allotee was there, page 151, and that was also complied with. My lord, these are my respective submission. But the only thing is that they offered with the 59 lakhs, which the widow won't be able to pay. So because I specifically took instructions for that.
Yes, this other division bench, the petitioner was ready and willing to pay the present market price.
Well, that present market price, I have the copy of is that notification of 10. But that the present market price for this leasehold is governed by that 2010 notifications.
That notification is not even referred to in this order.
But I have the copy myself with me.
What copy? This order doesn't refer to.
My order may not. All I'm saying, I have the copy that refers the notifications. But I have the copy with me. It is lordship that I can hand over. This is the copy that in Showman's case, same notification was followed.
Next page.
But every time they do follow the same top, kindly take, it's a compliance.
Next page.
Next page top. This is the notifications, my lord, that they, and in case of Mira also. The only other notification is the normal purchase. Well, at second page top.
Maybe market value and this notification were compatible in 2010 because this case is of 2011. 2023, 13 years down.
And they have a look at, my lord, the reference, the second page, not the first page. Second page, top. This is the notification of 8/10/2001. And that's the reason lordships want
2010, 8/10/2010.
Yes, sorry, 2010.
So if it is a notification of 2010,
yes,
the case is being discussed in 2011.
Right.
Market price and the price mentioned in the notification may not have varied that much.
Now Mira is in 2023. That is my case. Mira is 2023. And that's why lordships wanted to know, is it holding the field? Answer also came as yes. Well, I could have understood that they say that it is not holding the field. From
the learned judge has given you liberty to make fresh application. That we won't. That is always there with you.
That.
Sorry, Mr. Sir, we can't help you. It's state largest. It's public property. We can't help you. Auction, you participate, succeed, no problem.
Well, my husband was pursuing this case for 2001.
That is why they say because of pendency of the petition from 2001, they couldn't deal with the property.
No, my lord.
Which is a plausible reason.
Like it was for 99 years. Now 35 years is already gone. So even if I succeed, I will get only 65 years. And for 65 years to pay 16 lakhs, where I was supposed to pay 7,000, following the notification, my lord, may not touch upon the largest point. Lordship, kindly consider that. I was supposed to pay that remaining amount of 7,000.
this appeal. March 5, 2024. Past 5. Appeal 08 of 2, whereby disposing of the petition without granting the relief paid for by the petitioner. The petitioner's husband had
The husband of the petitioner number 1.
husband of the petitioner. A predecessor in interest of the petitioners, the predecessor in interest of the petitioners had been allotted a plot of land by way of lease. The plot of land you can be block number 389, block number 4B4 of block B of Kalyani Town, by way of lease by the government of West Bengal under Kachrapara Development Scheme. The letter of allotment dated April 19, 1999.
Yes, like any final payment chilo.
April 19, 1990. (1990) had the following terms. B. Had inter alia the following terms. The husband of the predecessor in interest now the original allotment, i.e. Mrityunjay Saha, since deceased, paid the earnest money, that is 1/3 of the premium or salami, in terms of the conditions mentioned in the said letter of allotment, but did not make the balance payment. Full stop. In terms of the in terms of the letter of allotment, the entirety of such payment was to be made within a period of 6 months from the date of acceptance of the said letter of allotment / order of allotment. Paragraph. Mrityunjay Saha expired on when did the petitioner number one's husband die?
Mrityunjay?
In 2018, I'm giving the exact date also. কবে মারা গেছে? My husband. বেঁচে দাও না, বক্তা দাও। And I'm giving that.
তার আগে একটা 6 years after having paid the
14th September 18.
6 years after accepting the letter of allotment, the said Mrityunjay Saha got to pay balance sum by way of a pay order dated June 14, 1999. Paragraph. The state manager and OST and ex-officio deputy secretary to the government of West Bengal returned the said pay order under the cover of a letter dated January 15, 2001, writing as follows. Subject termination herewith. Assailing the said letter, writ petitioners, the appellants before us. Now, Mrityunjay Saha, since deceased, approached this court by filing WPA 808 of 2001. মৃত্যুঞ্জয় এবার ওই প্যারাগ্রাফটা যেটা লিখেছেন ডাইট সেটা ওখানে ঢুকে দেয় তারপর the writ petition was ultimately heard by the learned single judge on March 5, 2024, after exchange of affidavits, and the learned single judge was pleased to dispose of the same by passing the order. Mr. Dhorl, a senior advocate appearing for the appellants before us, submits that the single judge, that the order impugned cannot be sustained in as much as the aim has failed to appreciate the import of the order dated March 25, 2022, passed by a division bench of this court in MAT 967 of 2018, within brackets, Shrimati Meera Sarkar versus the state of West Bengal and others, and the order dated April 24, 2012, passed in FMA 578 of 2011, within brackets, Somnath Bishwas @SOME NNATH Bishwas @bullet second name and another versus the state of West Bengal and others. Bracket closed. Full stop. He further submits that if in the aforesaid two cases, this court had allowed the appellants therein to avail the benefit of the scheme dated October 8, 2001, there is no reason why
2010.
There is no reason why the same scheme cannot be made applicable to the appellants in the present case. Full stop. Relying on the judgment of the Honorable Supreme Court in the case of Lieutenant Colonel Eta 1 Likha, it is submitted that if a citizen is aggrieved by an action of the government department, if a citizen who is aggrieved by action of the government department has approached court and obtained a declaration of law in his or her favor, others who are similarly circumstanced ought to be extended the same benefit. Full stop. Paragraph. He also relied on a judgment of the Honorable Supreme Court in the case of Tatu Likha and submitted that in a somewhat similar situation, the Honorable Supreme Court had directed regularization of allotment of site in favor of the appellant before it. Third, he next relied on a judgment of the Honorable Supreme Court in the case of Sri Likha for the proposition that the state cannot behave like a private litigant and rely on abstract theories of the burden of proof. Full stop. Paragraph. Mr. Shingupta, learned advocate appearing for the state respondents, submits that the scheme dated October 8, 2010 is not applicable to the fact in as much as the same is only applicable to transferors to transferees applicable in cases where in cases where the allottee has transferred or seeks to transfer the allotted land in favor of a third party. Full stop. It is submitted that this scheme aims at regularization of such transfers, which has not happened in the present case. Full stop. It is further argued that in the case at hand, the original allottee was never in possession, and neither have the appellants taken over possession of the property in question. Full stop. It is submitted that in the case of Mira Sutra, the transferee of the original allottee had taken possession of the property, of the relevant property, and had raised constructions thereon, which fact is not there in the present case, and which is a distinguishing feature. Full stop. Paragraph. Mr. Sengupta further submits that since the writ petitioner has not taken possession of, the question of having raised construction over the property also does not arise, and that full stop. Paragraph. Upon a query from court as to whether the plot of land can be regularized in favor of the appellants or not, Mr. Sengupta submitted that it could be possible if the appellants were ready and willing to pay the market price in respect of the plot of land allotted to them. Full stop. He further submitted that such regularization without payment of market price would not be possible, because that would affect state largesse, and in such cases the state authorities would prefer fresh allotments by way of auction, by way of public auction, where maximum price for the land in question could be fetched. Full stop. Paragraph. On a query from court, in answer to a query from court, Mr. Dhar, learned senior advocate appearing for the appellants. Mr. Dhar, your client is not agreeable to pay the market price.
Well, she won't be able to pay that.
Upon a query from court, in answer to
that's the market price for the usual transfer.
Yes.
That's
Mr. Thor, learned senior advocate appearing for the appellants, submitted that his clients would not be in a position to pay the same, and that they would be able to pay at the rate mentioned in the scheme dated October 8, 2010. Full stop. We have heard the learned counsel appearing for the respective parties and considered the material of the court. Paragraph. Two aspects are not in dispute. One, that the appellants, within brackets legally, and their predecessor in interest, have defaulted in payment of the premium in terms of the letter of allotment, full stop, comma, within the prescribed time, full stop. The payment made thereafter has been refunded to them. Full stop. B. The appellants and their predecessor interest within bracket have failed to raise construction over the property in question in terms of clause 8C of the letter stroke order of allotment, which was a mandatory condition, as would be apparent from the said letter itself. Full stop. Paragraph. We have taken note of the language used in the letter dated January 15, 2001, whereby the pay order dated June 14, 1999 for a sum of rupees 7,832 paid by Mrityunjay Shah since deceased. Paid by the original allotment, Mrityunjay Shah since deceased, was returned to the payer by the estate manager with the observation that the said allottee had acted in violation of clause 3 of the lease agreement and had become a defaulter in payment of 3 consecutive installments. Full stop. The said letter is captioned within brackets, within inverted commas, termination order in respect of plot number B-4/389 at Kalyani, inverted comma close. Full stop. The fine distinction, comma, which Mr. Dhar, learned senior advocate, seeks to make between the two letters, that is the one dated January 15, 2001, within brackets page 101 of the writ petition, and the other dated January 22, 2001, within brackets page 104 of the writ petition, would not cut much ice, as much as a holistic reading of the letter dated January 15, 2001 leaves no room for doubt that the lease granted in favor of the original allottees stood terminated by issuance thereof and by refund of the pay order. Full stop. Paragraph. Since the next condition, that is raising construction over the allotted land, in terms of clause 8C, has admittedly not been fulfilled, comma, non-mentioning thereof would in any way not make the termination illegal. Full stop. Paragraphs. Have gone through the order impugned, and we have found that the learned single judge has taken note of the two decisions of the division bench in case of Srimati Meera Sarkar Supra and Umnath Vissa Supra, and has distinguished the same by observing as follows. Page 174, during the course of argument. Set out. The aforesaid observations are correct in our comma in our view are correct. Indeed, in the case of Meera Sarkar, firstly it was a case of transfer which was governed by the scheme dated October 8, 2010, and the transferee had taken possession and has raised construction. And in the case of Somnath Vissas, the petitioner had agreed to pay the market price, then prevailing market price, for the land in question. In the case at hand, as already observed here and above, the writ petition, the appellants before us have not agreed for the same. Full stop. Paragraph. Mr. Dhar sought to contend that although the writ petitioner might have agreed to pay the market price as observed in the order dated in the order passed by the division order dated page order dated April 24, 2012 passed by the division bench in the case of Somnath Vishwa Supra. The set price was actually in tune with the notification dated October 8, 2010. We note that the close proximity of the dates of the notification dated October 10, 2010 and the order passed by the division bench might not have made much difference between the market price prevailing at the relevant rate and the one mentioned in the said notification. But 13 years down the line, situation may have changed. Full stop. In any case, since the order dated April 24, 2012 does not refer to such notification, we need not delve deep into it. Full stop. Paragraph. As regards the judgment in the case of LTCOL Suprita Chandelo 1 Supra, the same will not be applicable to the facts of the present case in as much as neither Meera Sarkar Supra nor Somnath Vishwa Supra laid down any law or made any declaration of which the appellant may seek benefit. The said orders were passed the peculiar facts of the case, which are evidently different from the facts of the present case. Full stop. Insofar as the case of Jaspreet Kaur Supra is concerned, a reading of paragraph 4 thereof make it clear that the Honorable Supreme Court did not decide any question of law. Full stop. To be precise, the paragraph reads thus, quote, after hearing learned counsel for the parties, but without expressing any opinion on the question of law. The paragraph, as regards the judgment in the case of Granules India Limited, Supra, there is no the proposition. There is no the proposition that state cannot behave like private litigant and rely on abstract theories of the body of law is quite well settled. But then, for the same to be applicable to the facts of the present case, it needs to be demonstrated that the state has acted arbitrarily or in a manner not compatible with the law obtaining. Full stop. For all the reasons aforesaid, we are not unmindful of the fact that we are sitting in a appeal over a judgment passed by a learned civil judge of this court in exercise of his jurisdiction under Article 226 of the Constitution of India. And by exercising such appellate power, we have to be cautious that we interfere only when the order is clearly wrong and not when it is not right. It's unexceptionable. Suppose limit 6 of 2020 and 1 of 6 of 2020 and specialists. It's all the papers there before us by consent of parties.
appeal itself for him and just your thoughts.
Only one thing I would like to point it out. Lordship has indicated the construction of the 8C clause. It will be instead of the 8C, 9C. It will be 9C. Interim order বলেছে কি?
It always goes into.
But the interim order stand vacated.
Interim order. Please, but automatic.
It is automatic. Well obliged.
Obliged to Lordship. I'm sorry, Millard. I was little late to enter, Millard. I'm so sorry, Millard.
All right. দেখো এগুলো নাও কিছু আছে এই পেপার
From 13 to 15.
Wait, I'm for the appellant matter. This matter relates to excise off license and the Bengal Excise Act. 2 points are really involved, 2 points. Whether a writ petition would at all lie for enforcement of a right grant of a licensee and the excise off license. This is point, the point not is covered by Supreme Court, no problem. This point arises because a learned single judge felt bound by order of another single bench, which has disposed of similar writ petitions on the ground that there is no fundamental right to carry on business in liquor, extra commercial gun. But the learned judge, in my due respect, missed the point that it was not a case, not a question of fundamental right. It's a case of right granted by law under the excise license, right to carry on business. Second point is, if there's so, in the facts of this case, what order should be passed? Now, I want to see the order on the appeal. 1 page only. Memo on appeal, 1 page. It's simply followed, had to follow, Lordship. His Lordship had to follow judgment of another single bench, which in my humble submission should be overruled by this. Can you see the
what did the writ petitioners ask for?
Page? Huh? Oh, prayer is, what happened? This excise license was granted, temporary excise license granted, as usual, for 6 months. After expiry of 8 days, I've enjoyed the license for 8 days. Excise Commissioner suspended my license, not because of any fault, on the ground that the general election is forthcoming, will be coming. And if I ground a false ground, the Election Commission asked him to suspend the license. Election Commission asked him to suspend only this category of license. All other licenses will be carried on. Anyway, he been suspended after 8 days. Election was over. General election was over. Even thereafter, order is not being revoked. Even thereafter, order is not being revoked. So, license remains suspended. After expiry of the tenure of my license, Excise Commissioner revoked the suspension order. There's no use. All license expired by that time. So, my submission is
order following minute, I'm relying on precedent of Justice Gordon's judgment earlier, similar fact, more or less similar fact, that my license should be extended for a period of 6 months, less 8 days, which I operated. Because of the period suspension, that period should not be computed.
Wrongful suspension.
Yes, an arbitrary act. That period of tenure of my license should be computed by excluding the wrong period of suspension. This is a judgment of the long part. That judgment was passed when there is no excise rule did not give that permission. Now, we have a stronger ground because the license under excise rules, I have right to get the license renewal of license. So these are the 2 points, Milord. May I first give you the first point?
You are for Borun Malakar?
Borun Malakar. Yeah.
Who is for Gautam Mondal and others?
I am for the Gautam Mondal, Your Lordship.
Very well. And Raju Ghosh?
Amra ki konta?
So, Mr. Banerjee, you are for in 13 and 15 for the appellant. Very well. Mr. Raghunath Chakraborty for 14. You are for the excise.
For the excise department, learned AG is leading me in this matter. And this matter was, Your Lordship, on the earlier occasion also, this matter was heard, Your Lordship. He was arguing in this matter.
I don't remember a thing.
Not before, Your Lordship. It was before the coordinate bench. This matter has been...
Through some fact.
Seven times it has been adjourned before the coordinate bench when the matter was being heard out on the ground of non-availability of the learned advocate general, including period when he was indisposed.
Yes, Mr. Banerjee, Mr. Mitro, today, as you know, we both have single benches at 3:30. So we'll rise within 2-3 minutes. We'll keep this as the first hearing item on Tuesday.
Yes.
And let us see.
And I would request my
Please request your learned advocate general to be.
My instruction is that kindly, if Your Lordship keeps it after vacation, Your Lordship.
This puts us in huge embarrassment, Mr.
Banerjee.
Puts us in huge embarrassment.
So the coordinate bench, 7 such prayers were acceded to by us.
অন্তত এদের শুনেনি নাকি ঘুরে দিয়ে বলতে হবে
We have a short list of dates for you.
Can you, Mr. Banerjee, on our request, have a dialogue with the learned advocate general and fix a date so that we can fix a date for him?
That will be better, Your Lordship.
I think that will be better. Yeah, I'll have a talk.
And come inform us tomorrow.
Yes, we'll do that at the first sitting. Yes, we'll do that.
Much
Because
that will be better. That will be better.
Yes, I mean, that will be
better for you, but not for my client.
No, correct. No. So presently we'll keep it on Tuesday, but tomorrow if you come and tell us a certain fixed date, we'll
maybe take Tuesday, subject to the consent of Mr. Advocate General.
Which also may be Tuesday, subject to what he says.
Very well. Lekho. Mr. Onindo Mitro, learned senior counsel representing the appellants in MAT 812 of 2024 and MAT 847 of 2022, opens his case, but does not conclude. Paragraph lists the matter as the first hearing item, as lists these matters. At the top of the hearing list on Bongolbar, tarikta diye daw. And informally, as we told you.
Yes, I'll put.
And Mr. Arbiter doesn't agree, then we shall intimate to your lordship, the matter will be taken up. I said, I should be intimated. I don't have to come early.
Well, before your lordships rise, may I just take 1 minute of your time?
Yes, Mr. Bose.
Well, the very next matter will not take time. Adhunik, yes. My lord had been pleased to refer this matter to mediation.
Acha.
Well, these were the last orders passed. We have informed the mediation center, but my lord, the mediator, I do not know whether he has been appointed because we have not received any information.
21st August.
So kindly, my lord, extend the time for at least a fortnight after the vacation, because we have not been informed.
Similar to us, but we are also not being informed.
I'll personally look into it. লেখো 16 নম্বর একটা অর্ডার করো। By our order dated August 21, 2025, we had referred the disputes between the parties to mediation. Stop. Paragraph. Both Mr. Bose, learned senior counsel for the appellant, and Mr. Shaha, learned counsel for the respondent number one, say that their clients have not heard from the mediation center. Paragraph lists this matter 1 week after the Puja vacation. Stop. The interim order that is in operation shall continue till the end of November 2025 or until further order.
But it is not a limited order. My lord, last
Oh,
order.
the interim order shall continue.
Shall continue.
Shall continue. এই আমি একটা চেম্বারে নিয়ে পাঠিয়ে দাও তো এটা আমার চেম্বারে পাঠিয়ে দাও।
Grateful, my lord.
We look into it.
Item number 34, 35, and 37. I'm praying for accommodation for the day, my lord. Not today, my lord.
Every day you do that.
34, 35, and 37.
Every day these matters are listed, you seek accommodation. Why?
Kindly consider.
No, why? Every day.
I have to take instruction.
What instruction?
Kindly consider, my lord.
No, what was it? 2018 contempt. What is this? Why?
I shall do next day, my lord. Kindly excuse
This
me,
is the submission you make every day. That you will do it next day.
Kindly consider, my lord.
May I have your lordship mention on contempt application, my lord?
7.
Let us see, the petitioner may not appear also. Let us see.
I'm for the petition.
Oh, you are for the petition?
Yes, my lord.
I see.
Well, that matter your lordship is released, my lord.
Oh, তাহলে করে দাও।
And that matter is 34, 35, 37.
This is not.
No.
33 of today's list, may I permit to mention?
33, you are the petitioner.
No, I'm for the respondent, but order has been set aside by the division bench and matter has been remanded back to the government.
Remanded back?
Yeah.
Very well. Then this contempt has to go.
Yes, this is the.
What was the order? Let me see.
Yes.
No, you have the single bench order. You have my order also, no?
No, it has been recorded in that. Your Lordship, 5th November 2015, passed an order. Page 3, last sentence, my lord. On such consideration, we set aside.
Oh, this is one of those Umadevi cases. Very well. Let it be called on. I will not do it out of turn. Daku.
Single bench matter, item number 1.
এসো আমি একটা বলে দিচ্ছি This is a very old appeal of 1956. Stop. The appellants have taken no steps for hearing or disposal of the appeal. Stop. Obviously, the appellants have lost interest in the subject matter of the appeal. Stop. Paragraph. The appeal is dismissed. Stop. Interim order, if any. Interim order, comma, if any, comma, stands vacated. ঠিক আছে তোমার খালি রাখো
2,
সেম
3,
সেম
4,
সেম
5,
সেম
6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23.
একবার দাঁড়াও শোনো Who is Shubhro Kanti Nando?
DI concern, DI concern. DI concern.
Present DI?
Present DI.
Then you have to make the appropriate change in the cause title. Cause title still shows Mitali Dotto. Has that change been made?
There has been subsequent changes, Lordship. Regularly they have.
করছিস না না দেখে বলছিস
আমি এই লোকটাকে কমিউনিকেট তো করি।
এই প্যান্টটা কোথায় ভাই?
party to the contempt.
There has been representation. So পুরো তো appear করেইছে।
It is event. Yes, yes. Shubhro Kanti Nando. কি বললাম? To the present District Inspector of Schools, bracket SE, bracket close, comma Nodia, comma, who is the alleged contemnor. Stop. Paragraph today, nobody appears for the alleged contemnor. Stop. Earlier, Mr. Nilotpal Chatterjee and Miss Oshmita Chakraborty, comma, learned advocates had represented the alleged contemnor. Paragraph, I request the learned advocate on record for the petitioner to have a word with Mr. Chatterjee.
Serve notice on him, Malad.
Oh, very well. To serve. Yes.
Mr. Nilotpal Chatterjee is on his legs before courtroom number 17, man.
Then his client has to go to jail. What to do?
A report. A compliance report.
Compliance report. Give it, take it.
আমাদের কপি দাও।
I think এটা বোধহয় ওইটাই অ্যাপ্রুভালটা।
এগুলো তো ফর্মালি করতেই হবে।
কিন্তু এরিয়ার জন্য
এরিয়ার জন্যই তো বলছি। দেবে?
No, there is a letter issued by the district inspector. We can see.
for disbursement.
For disbursal. To the teacher in charge.
Yes, yes.
তাহলে after vacation ই থাকবে সব।
Maybe after vacation, let us.
তাহলে কি এত কিছু লিখো না?
এগুলো তো
এত কিছু লিখো না। লেখো a compliance, an affidavit of compliance has been filed in court today on behalf of the alleged contemnor, being the present district inspector of schools, bracket SE, bracket close, comma Nodia. Stop. I see from the annexures to the said affidavit that a letter dated September 8, 2025 has been written by the alleged contemnor addressed to the teacher in charge of the concerned school which reads as follows. এই পেজ 9 এ আছে। ছোট্ট 5 লাইনের চিঠি দিয়ে দাও। Paragraph. Let this matter be listed once again 1 week after the puja vacation, whenever this bench is available. Whenever I sit singly, bench. But that's it.
Teacher in charge is to comply with the direction.
Paragraph, the teacher in charge of কি যেন স্কুলটা
ফাজিল নাগর হাই স্কুল
ফাজিল নাগর হাই স্কুল এই চিঠিটাই পেয়ে যাবে যেটা সেট আউট করবে ফাজিল নাগর হাই স্কুল is directed to act in terms of the letter dated September 8, 2025 written to him by the district inspector of schools, bracket SC, bracket close, comma Nodia.
Within
before at the earliest and
before the next
definitely by the end of October 2024 25.
Great. চলো
এটা কি ঠিক আছে
29.
Yellow next.
That's 20. 25 on for the contempt.
We will pass over.
30. 30 I am for the petitioner.
Now, the Lordship directed that today compliance report is to be filed. New incumbent has been already added and served. Right? Lawyer appeared.
So Chatterjee appeared on the last occasion, Your Lordship.
Have you
Compliance, Your Lordship, as per my report, compliance is not possible. The reason being there is no sanction post for this lab assistant, Your Lordship. That is my, those are my instructions.
So
Your Lordship.
that may be you're Mr. Sanyal, aren't you?
Yes, Your Lordship.
That may be your instruction. Please appreciate one thing. There is no appeal against the order. The order stands. So if necessary, you have to create post. Otherwise, go to jail. Let your client go to jail.
Recalling application rejected.
Recalling was filed.
Yes, recalling has been filed and it was rejected.
I'm not aware of recalling.
Rule has not been issued as yet in this matter.
Lordship, willful and deliberate. Why I'm saying this, I have got report, Your Lordship.
Mr.
that
Chatterjee say that the
sanction-
state wishes to file an application for recalling of the order. This stands the stand of the state is completely unacceptable to me. More than 7 years have been passed, gone by. After that order was passed, the order was not carried in appeal nor otherwise challenged. The last 7 years, the alleged contemptor is obliged to comply with the order. Lordship's observation.
Your Lordship, I can. Lordship, if
issue.
I can, at least I can, Lordship, hand over the report I have received. That no
Compliance
post
was
I have not called for any report. Yes, a compliance report.
compliance, Your Lordship. There is no post. As per my report, there is no post available, Your Lordship. Sanction post is not there.
Create a post. Why didn't you challenge the order?
Lordship, the present person who has joined is on 2024. Your
No, that is no explanation, sir, at all. It is the post that is important, not the
I'm aware of it. It's in perpetuity. Your
particular
Lordship.
individual.
It's in
Is the
perpetuity.
post of DI.
Yeah, it's in perpetuity. I'm aware of, Your Lordship. But the difficulty being is that he is unable to. I had a word with him when the matter was after the
Let
matter
him
was
then
taken.
come to court. Let him come to court. Issue. Read order dated February 14, 2025. Top. Paragraphs 4, 5, and 6 of the said order read as follows. Next. Mr. Shanyal, learned advocate appearing for the alleged contemptor, on instruction says, that it is not possible to comply with the order dated April 3, 2017, as there is no sanctioned vacant post.
Vacant post.
Stop. Paragraph 10. I do not find this to be an acceptable explanation. Stop.
Vacant.
Since the order dated April 3, 2017 has not been challenged over the last 7 years, 8 years. And are you sure recalling has been dismissed? Recalling was filed.
Application there. Lordship, they wanted to file it. Lordship.
No, wanted to file. I mean, I don't know. I don't remember it. And has accordingly attained finality, it is up to the alleged contemptor to figure out how to comply with the order. Stop. Paragraph. There will be a rule as prayed for. Stop. The rule is returnable 1 week after the summer puja vacation. Paragraph. The petitioners shall put in special messenger cost to expedite the service of rule on the alleged contemnor. Stop. Paragraph lists the matter 1 week after the puja vacation. Whenever I sit singly. রুলটা তো 1 week after vacation বললাম আমায় না পেলে রেজিস্ট্রার জেনারেল
On the returnable date, malady, if lordship is in a division bench, malady, he will go to the registrar and have his dispensed with.
That is what to do. Let him come at least, he'll understand, and he'll have to answer the rule. He'll have to answer the rule.
As well.
ওইখানে to figure out how to comply with the order যেখানটা করেছি. Stop. If necessary, comma, he may have to prevail upon the competent authority to create a post
That will be
for compliance of the said order.
Lordship, one request is that
A post or how many posts?
two posts both has two posts.
Create requisite posts, requisite number of posts.
Lordship, one request is that my instruction is that sanction vacant post, it's only sanction post is not there.
Sanction vacant টা বলো না যেখানে বলেছি no sanctions. It may have, Mr. Sanyal, please understand, it may well be an erroneous order.
He should have challenged it.
Should have challenged it.
I conveyed on the very first day, Mr. Chatterjee, before they have gone to Mr. Chatterjee, I told them very specifically, myself, I had a conversation with him, told him that you should have challenged, but your lordship, his reply is that I have recently joined. That's his reply.
31.
31, this is my application, my lord. Kindly see the affidavit service, my lord. Last occasion, your lordship on 29th August, my lord, directed the DI. On the next date, the alleged contemnor shall file a compliance report, my lord.
Yes.
I pay for 2 weeks time, my lord.
Sorry?
Times 2 weeks, my lord.
Huh?
2 weeks time, my lord.
Last
2 weeks time was sought for on 29th of August.
The rule be issued, my lord. Or direct my lord to come, direct the DI to come with compliance next week, my lord.
Not next week. Next week, don't burden us. Dekho, affidavit of service filed in court today. Be kept with the record. Paragraph. On August 29, 2025, learned counsel for the state respondent had obtained 2 weeks time for compliance of the order in question by the alleged contemnor. Paragraph. Today, again, 2 weeks time is sought for. Stop. This is most unfortunate. Paragraph. List this matter once again 1 week after the puja vacation. 1 week after the puja vacation. Whenever I sit singly. Stop. If on that date compliance report is not filed by the alleged contemnor, severe consequences may follow for him.
Well, 29th August, your lordship asked me to serve the copy. I have served the copy. Well, I am praying at this stage, rule may be issued.
my lord, 29th August. This matter, my lord, I have been told that I was appointed, but I find from the my lord orders that probably my lord Vidhan Bishash appeared and filed affidavits. My lord,
Affidavit in the contempt application.
no. First time appeared on 29th, your lordship passed an order to communicate the order.
Yes. To serve, we directed service on 29th of August.
August. What he is telling, I don't know. Or let a rule be issued, let him take instruction if you want to appear. If a rule is issued, but I will take instruction.
Will you appear for the contempt or?
My lord, I have been, my lord, given a copy. My lord, I do not find my name, my lord, in the.
We will direct you to appear and regularization.
My lord, kindly, my lord, then, my lord, give.
Otherwise, we'll issue rule.
No, my lord, kindly give me some time, my lord.
Then what will we do today?
No, my lord, record my name because it has been.
I'll give you time to file affidavit.
My lord.
Affidavit of service filed in court today be kept with the records. Paragraph, Mr. Dhol, learned advocate, appears and says that he is instructed to represent the alleged contemnor. C-pen-টা কোথায়?
এগুলো কি? বিশ্বাসের ওইগুলো আমি সবগুলো দিয়ে দেবো।
এইটা।
আপনি বললেন কেউ অ্যাপিয়ার করে। না, আমি এফিডেভিট ফাইল করা হয়েছে। সে তো করেছি, আমরা করেছি। এবারে তো করছি। আগে এফিডেভিট ফাইল করা।
Paragraph, let affidavit in opposition to the contempt application be filed within 1 week after the puja vacation. Stop. Reply thereto, if any, be filed within a week thereafter or 2 weeks.
2 weeks.
Within 2 weeks thereafter, এই তারিখগুলো দিয়ে দেবে bracket. Paragraph, list this matter 3 weeks after the puja vacation whenever I sit singly again.
And affidavit will be kept to the record.
Yes. This is that matter?
Yeah.
Yes. You are for?
No. State your lords.
Nobody appears for the petitioner. Stop. Nobody appears for the petitioner.
Page 3, the last paragraph.
Top paragraph. Mr. Mukherjee, learned APP, AGP, sorry, AGP. You see, I was on the criminal side for a long time, so get confused between APP and AGP. Learned AGP appears for the alleged contemnor and hands up copy of an order dated April 22, 2025, whereby a division bench of this court has set aside
5th November 2015.
Division bench of this court by an order dated. না বসে বললাম তো April 22 বলিনি? হ্যাঁ। Set aside the order dated November 5, 2015.
Yes.
Violation of which is alleged in this contempt application. So, paragraph. In view of the above, nothing remains in this contempt application. Stop. See, the rule stands discharged. WPCRC 10 of 2018 stands disposed of.
Get too much.
36, my lord. This is my application. This is affidavit service, my lord. My lord, pursuant to your lordship's direction 29th August, I have published of the DI of schools, my lord.
Nobody is appearing today. Yes, again, 2 weeks' time was sought for to comply.
Yes, my lord. But same order me passed item number 31, my lord.
31, item 31. There also 29th August last time.
Yes, my lord.
Same order.
Much obliged.
37. Belong 37, huh? 38.
Well, I am for the petition in this matter. Well, affidavit of service was filed on the last occasion when in the midway, my lord, the matter was adjourned because there is a ceaseword not to pass any advance order. Lordship took up the matter, but still, my lord, it was adjourned. My lord, Lordship, it is only with regard to the approval for payment, my lord, has already been made. Scale has already been given, but approval has not been done. Lordship wanted him to hold a hearing as far back as in 2018 to decide as to whether I will be getting it or not. Lordship did
Have
not.
you served? Have you served?
Affidavit of service is there.
Affidavit of service kothay?
Last occasion it was given, he received it personally. He received it on 22nd of May 2025. পেয়েছেন? বলো না যখন নিয়ে নেবেন দুটো হাতে করে।
ফাইলে আছে, ফাইলে আছে। অর্ডারটা হয়নি। কিন্তু অর্ডার হয়নি, কোডটা তো উঠে গেল। মিসপ্লেস হয়ে গেছে, সার্ভিসটা মিসপ্লেস। কপিটা
দিয়েছিলিস কেন? এভিডেন্স সার্ভিসটা ফাইল করলি কেন? মামলা হলো না?
Come back. I can't issue rule without having the affidavit of service.
এটাতে কি হবে? কপি উই হ্যাভ।
Let this matter be listed again 1 week after the puja vacation, whenever I sit singly. Stop. On that date, affidavit of service should be filed in court.
মানে হিয়ার ইজ এভিডেন্স সার্ভিস। আই এক্সট্রিমলি সরি।
Bojo.
মাই গড। তোরা আছে এখানে ফাইলে, তুমি দেখো না খুলে। তুমি কি করতে আছো? নিজে দেখো না খুলে। তুমি দেখো নি কেন? আমার ভাই দিয়ে হাত। আমি সেটা স্টুপিডের মতো কথা। ছিল 2018 order, accordingly, petitioner granted liberty to make a representation. We made the representation, but still.
Yes, rule.
Affidavit of service filed in court today be kept with the records. Stop. It appears from the affidavit that the alleged contender has received notice of this contempt application. Stop.
Added contender.
Only added contender.
New contender has been made.
The alleged contender.
Added. He is added.
সেই একই ব্যাপার।
Alleged contender.
উফ বাবা, কারেকশন করতে আসো তো।
Alleged contender oblique added respondent. Paragraph. Nobody appears for the alleged contender. Stop. It seems that the alleged contender has taken court proceedings very casually and lightly. Stop. Paragraph. There will be a rule as prayed for. Stop. Returnable 1 week after the puja vacation. Stop. Paragraph. The petitioner shall put in special messenger cost by Tuesday date by next Tuesday date to expedite service of the rule on the alleged contemnor. Paragraph lists the matter. 1 week after the puja vacation, whenever I sit singly.
Obliged to lordship. Grateful to you. Have it happy next. 39.
39, my lord, I am appearing on the petitioner. The order of your lordship has already been complied with by the contempt.
Wonderful. Learned advocate for the petitioner says that the order, violation of which is alleged in this contempt application, has been complied with by the alleged contemptor. Paragraph, in that view of the matter, C pan such and such stands disposed of.
Item number 40 is same, my.
40 same.
Clear. 41.
I am for the petitioner.
Mr. Maiti, you are Mr. Mukteshwar Maiti. The list says Muktokeshwar. Have you seen?
That is.
You should take strong exception to this.
Very technical mistake. My lord, in terms of the court's order, several orders were made. My lord, whatever, my lord, the 75% amount has already disbursed.
You were directed to file an affidavit. Have you seen the last order?
My lord, the
orderটা দাও ওনাকে। এটা দেখাও। 14th March 24. Look at the order.
the only one. Server হয়নি তো। My lord, the
File that affidavit.
my lord, that has been done.
File it 1 week after vacation.
Yes, yes.
By order date by an order dated March 14, 2024. 24, I had directed the
After the order, my lord, some payment already done. My lord, the things.
So give the latest position. I had directed the petitioners to file an affidavit containing particulars of the payment received by them and the payment outstanding. Paragraph, Mr. Maiti, learned advocate appearing for the petitioners, tenders his apology and says that by oversight, the affidavit has not been prepared. Paragraph, let such affidavit be filed within 1 week after the puja vacation. Stop. List this matter once again, 1 week after the puja vacation, whenever I sit singly.
Much. 42. Oh, sorry, 42 তো ওই লিংক ছিল না সেটা 43.
Yes, ma'am, I'm for the petitioner.
My lord, 43, I'm for the contemptor, my lord.
Your lordship, আমাকে বলতে হবে। Your lordship, the lordship's order is page
Disbursing the compensation.
yes, page 16. After that, my lord, I have filed this contempt application. They have did not take any steps. Save and extend, my lord, kindly have a look my contempt application. Here is, my lord, they have filed a chart by showing that the petitioners who are obtained, who will, sorry, my lord, the petitioners who will be entitled the amount, my lord. Thereafter, my lord, I have filed another petition before this honorable court. Now, my lord, Justice Aniruddha Roy, my lord, disposed of that petition by directing to deposit the entire amount before the learned registrar general. After that, my lord, they have deposited. Now, in this contempt application, they have filed an application for appropriate order. They, my lord, wants a clarification from a lordship the how and where they will deposit the money. That is, my lord, can 1. So my lord, money is already deposited. Now I pray before lordship, kindly give direction to the learned registrar
My lord,
general
that was
to
in the year
disperse the money.
2023, my lord.
Yes, yes. Contempt is 22. In correction of the contempt application, they have filed this application. Can 1.
They have not followed. With what prayer you approach Justice Aniruddha Rai?
Pardon, my lord.
With what prayer you approach Justice Aniruddha Rai?
My lord, I prayed because my lord, as my lord, there I have filed another application for releasing of fund. And but in that, my lord, because my lord, the save of the money, and the my lord Justice Aniruddha Rai directed the authority to deposit the entire amount before the learned registrar general. They have deposited. Now, my lord, prior to that, I have filed this contempt application. As so long the contempt petition was not, my lord, I could not, my lord, place, my lord. So, my lord, in that contempt application, they have filed an application for appropriate order. That is Can 1. That is appearing before your lordship. Can 1. They prayed that pass an appropriate order direction to the Farakka Barrage Project Authority, to whom the authority will deposit the land compensation. And after receiving this application of contempt, they have deposited the money before the learned registrar general. So in this aspect, my lord, only one, my respectful submissive lordship, kindly give direction to the learned registrar general to disburse the money in respect of the petitioners, or as per my lord.
Is in what proportion, who will get how much, how will the registrar know?
They have already, my lord, filed a chart.
Where?
Yes.
Annex to Can 1.
My lord, I'm sorry.
Where is the chart?
In my writ petition also, my lord. My writ petition, kindly have a look.
Oh, page 30, page 33.
Yes, writ petition, page 19. This is my, according to their my calculation.
Page 19.
On my writ petition. Contempt কোথায়? Contempt তো দিয়েছি, প্রেজেন্টেশন করনি কেন? That's the appropriate order. That's নাই। Lordship got it, page 19 of the writ petition.
Which writ petition, sir? There is no writ petition pending before me.
No, one writ petition only.
That was disposed of, no?
That is against whom the contempt application is filed. That is my writ petition number 8932.
Yes, there at page 19, there is no chart.
Page 18 and 19. No, this is their letter, the authority's letter. Next page.
এটাই বলছো
8932 2022.
This is the writ petition that you filed before. Before Justice Ray, sir, not before me.
Sorry, my lord.
Therefore, I am not.
Sorry, my lord. I'm extremely
Confusing at the end of the day.
I'm extremely sorry, my lord. I'm extremely sorry, my lord. My lord, 8932. 8932.
Come to the writ petition that I had disposed of. Do you have it?
Yes. That is 8932.
Yes. 8932, come to page 33.
Before your lordship. 8932. Yes. 33. Yes, my lord. This is the chart. Sorry, my
You
lord.
took 10 minutes to find out.
I'm extremely sorry, my lord. Because two repetition, I am confused, my lord.
Issue.
This is the chart they have, my lord, calculate, and after calculation, they deposit the money.
It appears that
My lord, compliance report, my lord.
no, it appears here though. Pura. Can 1 of 2023 is an application filed by the
Farakka Barrage Authority.
By the contender, ma'am.
Executive engineer, affirm affidavit, Farakka Barrage project.
by the Farakka,
Barrage project, executive engineer, Farakka Barrage.
by the executive engineer, Farakka barrage project, with the following now praying for an appropriate order regarding payment of land compensation by the Farakka Barrage Project Authority to the land losers. Stop. Paragraph. It appears that pursuant to an order dated January 14, 2025, passed on a writ petition filed by the present petitioners, being WPA 27346 of 2023, the Farakka Barrage Project authorities have deposited the entire land compensation amount with the learned Registrar General of this court. Stop. This you have stated in the compliance report.
Yes, my lord.
Get a copy we served.
Stop. This would appear from the compliance report in the form of affidavit
Page 4, my lord.
affirmed on July 14, 2025 on behalf of by the executive engineer of Farakka Barrage Project, which has been filed in court today. Stop. Paragraph. In view of the aforesaid, let learned Registrar General the amount of compensation is not mentioned in this chart.
No, my lord.
How much each individual will get?
This is, my lord, the according to their, my lord, chart, according to their acquiring properties, according land and my lord, and my lord.
How will the Registrar General calculate how much Jagir Sheikh will get, how much Sikandar Sheikh will get?
There is a rate fixed, my lord, in the chart. Rate
She'll
given.
sit down and do that calculation now.
Can give liberty? I shall file, my lord. I shall file.
In view of the the aforesaid, leave is granted to learned advocate on record for the petitioners to file appropriate application/representation before the learned Registrar General, clearly showing how much compensation each of the petitioners
that I'll do.
is entitled to. Stop. Upon as much verification as is possible, comma, learned Registrar General upon after. Learned Registrar General shall disburse the amount to the petitioners in accordance with the calculation submitted by learned advocate on record for the petitioners. Paragraph, no useful purpose will be served by...
Within a certain period, my lord. After receiving the calculation within certain period.
Stop.
My lord, the copy of the calculation may be supplied to us also.
Stop. A copy of the calculation made by learned advocate on record for the petitioners shall be made available to learned advocate for the
Just
Farakka barrage project.
98 লাখের বেশি হবে না।
Stop.
ওইটাই
We request I request learned advocate Bulchi, Registrar General to complete the exercise of disbursement of the funds within 8 weeks from the date of receipt of the application/representation from the advocate on record of the petitioners.
Maybe instead of 8 weeks, 6 weeks are too long.
Yes. She has enough work.
My lord, grateful, my lord.
See,
Much obliged.
CPAN and disposal of the CPAN and Can 1.
an application may be disposed. Grateful, my lord.
এটা কি?
I'm sorry, my lord. I confused regarding two.
Yes.
আমার ওই রিটটা দিন। থাকবে ওটা? Grateful.
My lord, I am for the petitioner. My lord, kindly see the 16th May 2025. My lord was pleased to direct to file a compliance report or the contemptor be present in court
Next time, my
as
lord.
to why he will not comply. Ordered on 29 December 2014. So, my lord, again, my lord, contemptor has been changed in the meantime. So, paragraph 4.
Same order as in 31 যেটা করেছিলাম 1
No,
week
but-
after vacation.
Present in court or present in court. No, on that order, my lord, it's
No,
not-
that we have said. আচ্ছা ঠিক আছে তুমি এইভাবে লেখো on
order দিচ্ছে।
on May 16, 2025, I had recorded an order, paragraphs 3, 4 and 5, 3 and 4 whereof reads as follows. এই উপরে আছে orderটা 3 and 4. Paragraph, Mr. Maiti,
Yes, my lord.
the contemptor should have been present in court today. That was the direction. If he has not filed the compliance report, he should have been personally present in court.
Yes, next.
No, Asim Ganguly senior, my senior Asim Ganguly, my lord.
Next,
Hey.
অনেক time.
I'll have him arrested.
বল আমি অনেক
ও বাবা
অনেক
ভদ্র মহিলা।
after vacation,
Paragraph
I'm paying leave to add the new
To-
contemptor.
new, changed.
Again, change three of contemptor has been in the meantime.
Oh, tell me that.
No, my lord, the order is there, added respondent, added contemptor. My lord, order is the 16th May. Paragraph 4. Paragraph 4.
Who is the present incumbent?
Present, my lord, the Joyanto Haldar. Suniti Sapui, in the meantime, my lord, has been changed.
Joyanto Haldar's name is not here.
Not there, but after passing the order, he has contemptor has been changed. After passing the
ওসব
16th
ছেড়ে দাও, ওগুলো সব ছেড়ে দাও। ছেড়ে দিয়ে লেখো। Let Joyanto Haldar, let Mr. Joyanto Haldar, the new incumbent in the post of District Inspector of Schools, bracket SE, bracket close, Murshidabad, be added as respondent in the contempt petition. Stop. Mr. Maiti, paragraph. Mr. Maiti, learned advocate for the alleged contemptors, says that he represents all the respondents, including the added respondent. Stop. No fresh service need be effected. Paragraph. Let the added respondent file a compliance report on the next date. Stop. In default, he shall be personally present in court. Stop. List this matter 1 week after the puja vacation whenever I sit singly.
Grateful. Only one indulgence, my lord. Your lordship give direction to the learned register to disburse the amount. But my lord, my respectful submission, my lord, if there is any, my lord, interest that may be kept in the legal aid, maybe some interest occurred, my lord, in the meantime of the total amount.
That you sort it out. Don't.
But until unless direction part
No. Very well. You make a gift of that interest. Leave it.
no, the kindly give direction.
No direction. I don't know.
Because my lord,
If necessary, mention it later. If necessary, mention.
my lord, grateful.
Bolo, next, last matter, bolo.
I'm for the petitioner, Lordship. First time, Lordship.
First time, thou.
So leave may be granted to correct the name of the contempt, Lordship.
There's a change.
Yes, Lordship. Lordship, sorry, I am wrongly typed the name of the contempt, Lordship.
Leave is granted to learned advocate of Likhcho. Leave is granted to learned advocate on record for the petitioner to correct the spelling of the name of the
Name, Lord.
alleged contempt.
Name.
Oh, the name of the, not spelling. The name of the alleged contemptor. Stop. Paragraph. Where's the order? Which order?
34, Lord. Page 34. Order dated, Lordship, 22nd December 2016.
This is an this contempt application has been taken out, alleging willful violation of an order dated December 22, 2016,
Yes,
comma, whereby I had disposed of WP 17711 bracketed W of 2016. Stop. The operative portion of the order reads as follows, page 35, running page 35, bracketed portion. Paragraph, learned, no decision taken till date. Learned advocate for the petitioner says that in spite of due communication of the said order, comma, till date, comma, no decision has been taken by the alleged contemptor. Paragraph, let a copy of the contempt petition be served on the...
Lordship, may I also dismissed for default and also dismissed.
Huh?
The contemptor filed, Lordship, appeal, Lordship. And may also appeal also, Lordship, dismiss. Turn second page, Lordship, 36, page 36.
That's dismissed for default.
Consequently, the appeal number
this
then dismissed.
না না ওই জায়গাটা
Para 3.
Yes, follows তারপরে কি বললাম? In spite of due communication, paragraph, she further says that the appeal preferred against the order dated, ওই আমার orderটা 16th কত একটা জানো, was dismissed for default by a division bench by an order dated
Come also para 3, Lordship, the appeal order, Lordship, page 36.
Yes.
6. As consequence, the appeal being emitted number of
That is what I'm...
And also dismissed, Lordship.
What am I saying, madam?
Sorry, Lordship.
কি মুশকিল, কি বললাম? August 2, 2024. Paragraph, let a copy of the contempt petition be served on the alleged contemptor and affidavit of service be filed in court on the next date.
Yes, Lordship.
Paragraph, list this matter 1 week after the যা বলছিলাম, whenever I sit again. Hey, Passover আছে.
My lord, with regard to Passover 29, my lord, there is a direction.
Please, Mr. Chakrabarty, let him call. 29.
29.
Yes, you are for whom?
My lord, I am for the alleged contemptor. My lord, last occasion, my lord, 23, my lord.
Hey,
my lord,
usual dismiss for nobody appears.
my lord,
Nobody appeared in the first call.
My lord, preferred that appeal, my lord, succeeds and my lord, order passed by my lord that is under contempt is my lord goes.
Nobody appears, I'll simply dismiss it.
So kindly record my
very well.
submission of
দাও,
record. There is a direction.
দাও। Nobody appears for the petitioner, লেখো। সেই জন্যই appear করেনি।
Yes, my lord.
Stop.
I requested them also.
Nobody appears for the petitioner. Stop. Paragraph, learned advocate for the alleged contemptor. One contemptor.
My lord, subsequently two added, my lord.
Alleged contemptor. Alleged contemptor. Hands up. Copy of an order dated April 28, 2023, passed in MAT 690 of 2017, whereby a division bench of this court set aside the order dated June 2, 2016, violation of which is alleged in this contempt application. Paragraph, in view of the aforesaid, nothing remains in the contempt application. Paragraph C-PAN such and such is dismissed.
Grateful.
Next, আরেকটা আছে নাকি? Sure. চলো যাই।
Not happy Pujo Mala before
Happy
Pujo Mala.
Happy Pujo.